Hello. Hello, everyone. We should be live, hopefully. I feel like I don't feel like, in reality, I start every single one of these with a technical difficulty. Sorry, guys. Okay, I'm definitely live. Oh, to be Lauren. Good morning, everyone. I didn't even shut my door all the way. Hold on, I'll be right back. Okay, guys. Oof, 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 oof. What a week, man. What a week. Good morning, everyone. Thank you for being here. I am Lauren Cadillac, aka OG Cadillac, aka Mother of the Decade. And if you know me, you know I'm an attorney in the Dallas, Texas area. And I am also a fan of trials, watching trials. I am an attorney, licensed to practice in the DFW. Well, I'm licensed to practice in Texas, but I live in DFW, and I do mainly real estate related practice. That is a highly litigious practice, so we do a lot of courtroom work. I am definitely a courtroom attorney, and I love watching trials. I actually started watching Alec Baldwin, guys, in the absence of YSL. And if any of you are watching it, did you see him like just get up and walk out yesterday? He just like got up and walked out. The prosecutor is like in the middle of reading something, you know, and he just stands up and walks off. He just like walked out of the courtroom. The reason that's hilarious is because you don't leave a courtroom without asking the judge's permission to leave the courtroom. You have to say, may I be excused? All right, before we get into the meat and potatoes, I want to do some thank yous. Thank you to all of my members. Y'all are awesome. I did a special members only video this week, and every single one of you watched it. You're the coolest. I want to thank my my moderators. I want to thank my moderators who do a great job in the chat at moderating for us. I would like to thank Travis Haight, who may or may not be here, who designed this Lady Justice for us, and the merch is going to come live. I have a shirt. I have links to our artists for the stickers. I have links to the artists for the merch. And then a really special shout out to Miss Tina, who sent me this gorgeous tumbler. Can you see the cute little... First of all, I love bling. I love bling. I love pink. And I had been wanting a tumbler, but my daughter like had stopped me from getting one. So now I have one. Thank you. Thank you so much. Thank you so much. I really appreciate it. Thank you to everyone who's hit like. Thank you to everyone who's hit subscribe. And thank you to everyone who's cashapped, everyone who sends their super stickers. I appreciate you all. Thank you to people who send me earrings. I actually bought these for myself. When, last week when Belinda and I played hooky, we went accessory shopping and I got these earrings and I love them. Okay. Rico says, does Woody know this is all his doing? And he's starting a YouTube page. This is not all Woody's doing. Woody wishes this is all his doing. Bumpus also started a YouTube page, so everybody who could profit off of this is trying to. Myself included. I mean, I'm no different. I've been following the trial, and I've been talking to you guys about it. Y'all send me Cash App. That's me profiting, you know, so. It's the way the cookie crumbles. Welcome to 2024, y'all. Okay, no, I'm not going to talk politics. I'm not going to do a refrain. I'm going to refrain from talking politics. And I'm also going to try to refrain from singing, but you know I do a terrible job at that. Okay, so we didn't get to see any of our fabulous YSL team this week, but we read a lot. All right, So on Monday, Miss Love submitted. I almost like can't believe she submitted. What day was Monday? Monday was the 8th. Okay. I really can't believe she submitted it because of the results. So she submitted a motion to have an extension to respond to the defense's recusal motion. And on Monday, she asked for a 48-hour extension because of some family emergency, okay? Hey, Kay, thank you. I'm getting there, but my eyes are not expressive. They're dead. Just kidding. Hey, it's step by step here, okay? With y'all's support, I was able to buy a better computer. And with y'all's support, I've been able to get a better camera. So we're now using the better camera. And as you continue to support the channel and we continue to grow, things will get better, okay? I love your feedback, but it's taken a while. It's slow to grow, y'all. Hi, Tamika. Good morning. Good morning, Nia. Good morning, everyone. Chris, Caden, breaking it down. Did I see a Red Bunny in here? Tall Glass, Nene. Good morning, everyone. Mel Parker, Serena. Okay. Okay, so Monday, Miss Love asked for time because she had a, quote, family emergency. Well, y'all know that Miss Love doesn't actually have family, right? She has family, but she doesn't have her own family. She's got her, she's got nieces and nephews, but she does not have, children of her own. So it's not like she had a child in crisis. Not that that's more important than having a niece in crisis or something. I'm not judging in that way. So she had an alleged family emergency. I feel like family emergency is like the fallback of all attorneys in terms of like why we can't do something. Oh, it's a family emergency. I want to come up with a better one though. Like, I want something better than just family emergency. Okay, so Love did a request to get 48 extra hours, and that was granted. Okay. On the same day she asked for that request, on the same day she asked for the request, Steele supplemented his motion to recuse Glanville. Okay. So I'm doing things chronologically here with you. So we're going to go from Monday at 8:30 p.m. and then we're going to go to Tuesday and then we'll hit Wednesday. Okay? All right. I don't know. I don't think anything has been filed Thursday or Friday. Or maybe the state's response was Thursday, but obviously right now is Friday. So I forgot. It is. Now is Friday. Thank God. Okay, here we go. Mr. Jeffrey Williams, by and through undersigned counsel, and hereby timely files the motion for supplement. The supplemental motion and the attached affidavit is timely, blah, blah, blah. All right, let me hit these footnotes, okay? First, the motion applies to Love and Hylton in court, in addition to Glanville, as all three are material witnesses in the case at bar and will be called by Mr. Williams during trial to show judicial and prosecutorial misconduct, and he quotes Reed v. State. Also, I just want you to take note, like this right here is the halfway mark of this page, and he's already filed a support, here's this rule, okay? And then below that, we have Reed versus State. The reason I want you to think about that and consider what's going on there is I want you to compare it when we get to Love's response. Okay? Okay. Okay, footnote 2. This motion also timely moves to recuse Honorable Judge Krause based on the fact that she sits in Fulton County with Glanville, and in April of 24, Glanville contributed $2,000. Where is a government employee getting this kind of money to donate to a campaign, y'all? What? Also, in April, Honorable Judge donated $500 to Glanville. See, that's much more. That's much more government employee to me. Okay. Mr. Williams' trial is ongoing and therefore includes April. And then he cites 1, 2, 3 cases. 3 cases. Just right here, right off the bat, y'all. Okay? Now, when we get to Love's response, it's going to be a stark contrast. So that is why I'm pointing this out to you. All right, there is purpose behind the madness at times. Okay, the joint affidavit I can't wait to get into. It's real juicy. The Honorable Supreme Court of Georgia has taught that motion to recuse is timely if it's filed within 5 days. It's weird that he says has taught. He says that all the time, taught. And I'm like, why doesn't he just say stated or ruled? I don't know. Okay. Thus, the supplement to motion to recuse is timely and blah, blah, blah. It's also been presented to Krause and Glanville on the 8th. In the case of Barr, Glanville's ex parte communications with sworn witnesses, his counsel, lawyers Love and Hylton, and other representatives within Fulton County District Attorney's Office are seemingly only partially captured by the court reporter. Now remember, we went through, like, is this the full transcript? And we analyzed so much of that transcript. We went through word for word, every word of that transcript. And you know what was missing from that transcript? The coughing. A good transcript will have, so-and-so coughed or, whatever. But we don't have a good transcript. We have a highly adjusted transcript. I feel like you guys are so close to my face. Are you cool with that? All right. All right. Glanville lawyer, okay. I pointed this out with one of his last motions, but I'm going to point it out again. Notice how he lowercases lawyer and lowercases lawyer Hylton, okay? Just keep that in mind as we go along. Have prejudiced and tainted Williams' trial so deeply, Glanville has not acted as judge, but morphed into an essential part of the prosecution team. And then he issues an example of when that was not allowed. Judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impeding matter, yet Glanville participated in them and somehow attempted to keep them secret by referring to them as privilege and describing the improper secrecy as sacrosanct. Yeah, we all know that. We saw that when he was yelling at Steele. How did you find this out? This is sacrosanct. And then we see the reason he's so upset is because he's clearly acting inappropriately in this meeting. Well, having the meeting was inappropriate, but Glanville has abandoned his role as judge and become a prosecutor against Williams. Ex parte communications are presumed to be harmful error. Boom. Like on his face, that's harmful error. Unless the state proves the error was harmless. So the state has the burden of proof to show that the error is harmless. Now, mind you, we have another citation. We have citations throughout this, okay? And not just citations to the record of this case, citations to like actual laws and other cases. Williams timely raised his objection to the ex parte communication and recusal of Glanville to wit when he first learned of the same. Canon 2, Rule 2.9 of the Georgia Code of Conduct forbids a judge from considering ex parte communications, as judges shall accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to law. Judge Glanville embraced his view that the communication at this ex parte hearing were privileged. Judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside of the presence of their parties or their lawyers concerning the impending proceeding, except communications for administrative purposes, emergencies, consultations with experts, or court personnel and settlement conferences. I think that that is pretty clear. Pretty clear. Hello? It's like pretty much right there. Here are the 4 times you can have a meeting. Hello? Just like, it's, all right. I want to say it's shocking to me, but I've been practicing law for long enough that I have seen crazy behavior. crazy behavior out of judges. So it isn't that shocking, but here's the deal. I do civil law, right? Like, I'm doing civil law. The thing that is at issue in what I'm doing is like a piece of real property, like some land in a house, or, you know, some money, right? There's not like lives at issue. So when judges in the civil courts act up, that's one thing. You know, money is money. They'll just print more, you can make more. It is what it is. But I only get one life, and if I have to spend it in jail, that's different, right? That's very different. So this kind of behavior out of a judge is just, and the other reason it's not that surprising is because of the behavior of our ex-presidents and continued behavior of presidential candidates. Like, decorum is no longer a thing here in the United States. Like, that's done for. I'm hoping that some judges come back and like bring it back in, but who knows? Who knows? Okay. Dude says many judges do ex parte hearings or meetings without one or the other side. No. Incorrect. You're not supposed to be doing that. If they are, that is a big problem. Okay, off my high horse, back to the document. The Code of Judicial Conduct is clear. Ex parte communications are presumed to have been an error, and once a party has shown the judge that has received an ex parte communication, there's a presumption of harm that can be overcome only by an affirmative showing that the judge did not consider this communication. Where are you going to find an affirmative showing that Glanville didn't consider the entirety of what happened in that room? It's literally impossible. Cannot be done in this case. In the case of Barr, here we go. In the case of Barr, there is not a scintilla of evidence to overcome the presumption that these impermissible, illegal, and unethical ex parte communications, as captured in attached Exhibit B, resulted in harm. Thus, Mr. Williams' case should be reversed on direct appeal if there's any conviction and sentence. So, do you guys remember when when the contempt thing was going down? Then we had Ashley Merchant come in, and she was talking to the judge about, hey, this is how this works. She explained all of that to us. Well, after that, I came on and I did a video, and I explained to you that this recusal is going to be heard. Remember, the Supreme Court allowed a bond for Mr. Steele, right? When the Supreme Court reviews this and they see an error such as this ex parte meeting, they will have to call a mistrial. I feel, and I don't know if another judge would have the jurisdiction to do this, but if Krause recuses Glanville, I feel like she might have to declare a mistrial. Like, you can't just go on with this trial. This harmful error has occurred, so we know if we go forward with this trial and we get a jury conviction, it will be reversed on appeal, period, end of story. So we'll see. Actually, that's a great time. This is a great time to remind you that I am going to be in Atlanta on August 13th. If we have court, I'll be in the courtroom in the afternoon of the 13th. If we don't have court, I will be at the meet and greet, which I tried calling the venue and they didn't answer the phone. So I have to try calling again to secure the venue, but I don't have that quite yet, but I will, and I'll announce everything. And then on August 14th, if there's court, we'll meet in court again. But if there's no court, you just get to see me at the meet and greet. Sorry, guys. August 13th in Atlanta, Georgia. I'm really looking forward to it. I'm going to have 2 special guests at the meet and greet. Miss Infamous Sylvia, and Mr. Seti Nash. That's how I roll, y'all. That's how I roll. Okay. All right. I hope that all of you can make it to Atlanta. Here we go. Let's see. As shown in the joint affidavit, Judge Glanville not only conducted this improper and unethical meeting, he acted as an advocate for the Fulton County DA as he dispensed legal advice and supported lawyer Hylton and Love School to have Mr. Copeland testify against Mr. Williams and the other co-indictees. In light of this ex parte proceeding, it's impossible to conclude, impossible, y'all, to conclude that Judge Glanville is impartial and not a member of the prosecution team. You guys know I love the way that Brian Steele is so dramatic. I love it. I'm like tempted to get in criminal law just so I can be dramatic, because I am dramatic, and so it's like a really good fit. But you know, usually in criminal law you don't write this many motions. Like this is way, like most of criminal law is like physically being there, not writing and arguing motions. So I don't know. Okay, I see some questions about Krause. I don't know what they are specifically, but my understanding is that Krause should also recuse herself simply because she is in Fulton County, and the writ that YSL IP Weinstein filed went to a Fulton County judge, and she immediately recused herself. Sua sponte, which, as I told you guys, means on her own, basically. She recused herself because if it's a recusal of a judge in your same area, then you are supposed to recuse yourself. So, hey D-Mom, did you see that gorgeous tumbler? All right. Judges shall disqualify themselves in any proceeding. And y'all, the word is shall. It's not may. It's not a question. It is a command, shall. They shall disqualify themselves in any proceeding in which their impartiality might be reasonably questioned, including cases in which the judge has a personal bias or prejudice concerning a party or party's lawyer, or personal knowledge of disputed evidentiary facts concerning the proceedings of judicial, the proceedings code, has been derelict. Ooh. Like, do you guys, have all of you watched Zoolander? And if you haven't, please, after this, immediately go do that. Okay, Zoolander is one of my favorite movies. Do you remember in Zoolander, Will Ferrell is like Mugatu, and he is a designer, and he calls his, like, he has this design and all the clothes are like make you look like you're homeless, and he calls it derelict instead of derelict. And then at one point Zoolander says, "I'm gonna derelict your balls." Freaking love that movie. Anyhow, besides the movie Zoolander, I have not really ever seen derelict in like usage, so I'm very excited to see it here. Gonna derelict. Oh man, Zoolander is such a good movie. My daughter even liked it. She's only 11 and she like watched it with me and she was laughing and cracking up. Okay. Once evidence of this illegal ex parte Star Chamber meeting was revealed by undersigned counsel in the afternoon, in the afternoon in open court, lawyers Hylton and Love sat mute while Judge Glanville found undersigned counsel in contempt of court and sentenced undersigned counsel to the longest possible time in jail for unmasking Glanville, Love, and Hylton's improper and illegal and unethical conduct. That's a bomb drop, y'all. So Steele's like, they let that man persecute me, knowing everything was wrong, and they didn't do shit. They didn't say a damn thing. In addition to violations of Georgia rules of professional responsibility, which could carry penalties up to disbarment, felony crimes such as violation of oath of office. Damn. The reference section of Georgia Code of Judicial Conduct are meant to be self-enforcing, and it's the judge's duty to disqualify himself as soon as he is aware the grounds exist. Sua sponte, right? As soon as you know the grounds exist, you are supposed to disqualify yourself. So, as soon as Glanville knew that Steele knew that they had the meeting, he should have recused himself. Quite frankly, he shouldn't have had the freaking meeting, but that's another one. All right, that's all quotes of law. Again, this is a whole paragraph just citing the law, y'all. Keep that in mind when we head to Miss Love. In this case, the state cannot show that Judge Glanville's lawyer Love and Hylton's intentional and willful complicity in these ex parte communications was harmless error. As shown in B, the improper influence and interjections by Glanville and his two cohorts from the Fulton County District Attorney's Office on Mr. Copeland changed Mr. Copeland's stance not to testify against Mr. Williams. If Mr. Copeland refused to testify, all of his prior false and inculpatory statements asked to Mr. Williams would not come into evidence based upon Mr. Williams' constitutional right to confrontation. So because Thug has a constitutional right to confront a witness, if Copeland chose not to testify, then all those videos and such would not come in. It would not come in. Even though they have the detectives, because Thug and every other defendant in America has the right to face and confront their accusers and the witnesses, he has a right to talk to all the people in the video. So if they don't get Woody, they don't get the video. Intimidation tactics thrust upon Mr. Copeland by the combined work of Glanville, Lawyer Love, and Lawyer Hylton resulted in Copeland's decision to testify, and thus, Mr. Williams has another witness to challenge at trial. Moreover, ex parte communications are so disfavored and repugnant, I love that word, that even if the ex parte communication would be cumulative of other evidence introduced at trial, same would not be harmless error because the ex parte communications are presumed to be reversible error. It's reversible error, period, full stop, done, game over. Mr. Williams' fundamental constitutional rights were trampled, ignored, and violated as a result of Judge Glanville's, Lawyer Love's, and Lawyer Hylton's improper, unethical ex parte meeting with witness Copeland. Moreover, the cover-up, secrecy, and silence of these three team members is unforgivable. To wit, after the Star Chamber meeting, the three public officials simply strolled into the courtroom, faced the cameras, called for the jury, and feigned to continue trial as if nothing out of the ordinary had occurred just hours or minutes before. Wow, y'all. That is, woo, powerful. Powerful. Mr. Williams needs to examine Judge Glanville, Lawyer Hylton, Lawyer Love, and all other members of the prosecution team to reveal the date and time of every ex parte communication that occurred concerning Mr. Williams' case since its inception. The subject of the same order, the court reporter, to produce any transcript of same and or unseal all documents from these potential improper ex parte communications. So, Steele is saying, hey, since you had this one improper ex parte meeting, there's a high chance you've had several others. I'm going to need to know about them, and I'm going to need the transcripts. Seems fair. Undersigned counsel needs to cross-examine all of these parties to ensure that sworn testimony is spread in open court on the record. Love it. I love how he's like a smartass, but not a smartass, you know? Like, he's a smartass. Well, I guess that's why it's a smartass, because they're smart. One time when my son was really young, I said something to him and I said, okay, smartass. And he said, rather be a smartass than a dumbass. And I was like, you know what? You're right. Such a good point, son. Oh my God. Never thought of that. Anyhow, if you're just joining us, I am Lauren Cadillac. I'm an attorney in Dallas, Texas. I am a litigation and courtroom attorney. I like to watch other trials, other attorneys work. It helps me be better at what I do. I started following the YSL trial because of the constitutional issues, using the First Amendment and using, lyrics against someone. And it has just been a shit show, and I have loved following it. And thank you for following me. Make sure you like and you subscribe. We are following YSL, but the next one we'll do is going to be Sarah Boone, unless we have more YSL. And, like I said, I watched Alec Baldwin's trial yesterday because no YSL on. So thank you for being here. Make sure you hit like and subscribe. We are still very much on YSL Steele's motion to recuse, his updated motion to recuse. Mr. Williams' trial is constitutionally broken based upon the unconscionable misconduct of Glanville, Lawyer Love, and Lawyer Hylton, all working together in an effort to convict Williams. The criminal justice system in Fulton County, the state of Georgia, and America has been attacked by these three actors. This injustice must end immediately, beginning with Glanville removed and disqualified from Williams' case. Thereafter, this motion is also timely made for Lawyer Love and Hylton to be removed and disqualified from Williams' trial, and the Fulton County DA's office must be investigated for their improper conduct, if any, outside the actions of Lawyer Love and Lawyer Hylton. Pretty serious. It's pretty serious. Slick, welcome. I'm glad you're here. How do I feel about a sworn witness making YouTube videos? I don't really have feelings about it. Can't say I blame him. Probably not great in terms of what he's talking about on the videos, if he's talking about anything related to the trial. And certainly I'm guessing that, Shard and Steele and all of them are watching those videos intently. Yeah, Nikki says Kayla must have been advised to stay out of the YouTube streets. I don't know, who knows, maybe she just hasn't had anything else to talk about, really. All right. Judges must scrupulously avoid improper ex parte communications, whether or not they consider them. A judge has an ethical duty to recuse himself sua sponte, remember we talked about that earlier, anytime the judge is aware of the grounds to do so, period. So if the judge knows you have to, if the judge is aware that they need to recuse themselves, boom, they must do it. If a judge is presiding over a courtroom and looks down and sees a defendant's name, it's a really distinctive name, like Lauren Cadillac. There's only 6 or 7 Cadillacs in the whole United States, right? So and they know that, like, oh no, oh shit, Lauren, oh, I hope she's okay, but I gotta recuse myself, I know her. You see what I'm saying? So, yeah. Glanville did the opposite of recusing himself. Even though he's keenly aware that helping Lawyer Love and Lawyer Hylton to influence Copeland to change his mind and testify against Williams is not permitted by any judge in any court. Instead, Glanville, the chief judge of the Superior Court of Fulton County, has taken upon himself, at the behest and encouragement of Love and Hylton, to ally himself with prosecutors in this case. His misconduct shall not stand. The law must be followed. Glanville must be recused and disqualified from Williams' case instanter. I'm going to start using instanter. I'm going to say that to my daughter. Young lady, those dishes must be done instanter. She's going to look at me like, what the F? All right. Let's see. No hearing is actually needed to reach the finding that recusal of Glanville instanter is mandated. Glanville automatically caused his recusal and disqualification from Williams by unlawfully becoming actively involved when he presented argument refuting affiant's allegations of judicial bias. So, Remember, Glanville was like, oh no, how'd you know about that? Well, it's an automatic recusal because he presented argument. He became an advocate. Judges don't get to present argument. Judges are just there to make rulings. That's it. Socialize a little, you know. If this honorable court disagrees, Williams respectfully requests a hearing as he will call Glanville, Love, and Hylton as witnesses to fully unmask this above discussed misconduct as well as further misconduct that may have occurred. And see, that's the problem here. Glanville has really put him he's put himself in a position. Remember when Bumpus wanted to be removed and he was like, oh, well, you did this to yourself. I'm sorry you put yourself in this position. Well, guess what, Glanville? You have put yourself in a position, okay? He has now put himself in a position to open floodgates of inquiry about misconduct. I mean, a floodgate of inquiry about misconduct. After seeing this misconduct, don't you believe that every defendant that's ever been before him is going to go back and go through their whole record and see if they can't somehow chalk up their guilty as misconduct? And if you don't think that's the case, then y'all have not been watching. Y'all have not been here, okay? Glanville has opened a door that he should not have ever opened. Ever. Okay. This judicial and prosecutorial misconduct denotes a disgraceful episode in Fulton County courts, the Fulton County District Attorney's Office, and stains court through the state of Georgia and our country. What occurred at the Star Chamber, outside the views of the cameras, in the shadows and hidden from Mr. Williams and his counsel and the public, is unpardonable and all in violation of Williams' constitutional rights stated herein, as well as in Exhibit A. Y'all, that was a very long sentence. Hold on. What occurred? Okay, I guess it wasn't that long. It just felt like a lot. It felt like there should have been like another, like a semicolon or something, but I think it's not that bad. Sorry, I thought I had to sneeze. Okay. As the Honorable Supreme Court of Georgia has taught, it's so weird that he says taught. I don't know why he uses that. Justice faces its greatest threat. Why doesn't he say said? As the Supreme Court has said, ruled. It's very strange to me how he says taught. Faces its greatest threats when courts dispense its secretly. Our system abhors Star Chamber proceedings with good reason. I love the word abhor. I love the word abhor. It is like so dramatic. Oh, abhor. Abhorrence. Okay. Glanville, Love, and Hylton teamed up to conduct their illegal and unethical conduct outside the views of Williams and his counsel, the public, and outside the lens of the cameras. These public officials shall never be trusted by Williams or underside counsel. There are serious consequences for these intentional and unjustified misdeeds that have not yet been dispensed. The clear evidence is that Glanville is not impartial, or at least there's some appearance that Glanville is not impartial. He must be removed. As sworn into A, Glanville, Love, and Hylton conspired to conceal and suppress. This Star Chamber cannot prohibit Brady evidence from coming forward. That is exactly what Glanville, Love, and Hylton plan to do. Mr. Williams' constitutional right to due process, a fair tribunal, a fair trial, effective assistance of counsel, right to cross-examine, right to see, hear, and be present for the statements of the sworn witness have been obliterated by Glanville and his cohorts. Glanville must be removed as he has forfeited his position as judge. I just love this motion, y'all. It is so dramatic. I love how dramatic he writes. I just love it. It just is so much more fun to read. It's really dramatic. Okay. Okay. The June 10th, 2024 Star Chamber meeting between Glanville and lawyers Love and Hylton undermined the public's faith and integrity of the justice system as it conceals from the public Mr. Williams, his lawyers, and the others facing the removal of their liberty critical information about lawfulness and reality of how they are being prosecuted. This injustice must end today. The trial is wholly broken and cannot ever be repaired, based solely on the improper conduct of Glanville, lawyer Love, and lawyer Hylton. Any motion for mistrial made by Mr. Williams is based exclusively upon the improper actions of the supposed judge and state actors. He said supposed judge, not the judge, supposed judge. I'm here for the drama, y'all. I just love this motion. I love how he writes. Glanville at the indecorous Star Chamber ex parte meeting provided legal advice and direction to Attorney Bumpus about how to speak with her client, Copeland. Dispensing legal advice creates a clear appearance of partiality, which is proper grounds for the granting of this motion to recuse under our Code of Judicial Conduct and the Constitution. Mr. Williams' constitutional right to due process has been violated because not only is there an appearance of partiality, but there is actual bias, as Glanville has been embroiled in this trial and is assisting prosecution to attempt to gain conviction of Williams. It's impossible for any reasonable person to believe Glanville is neutral. Glanville must be removed based on the one ex parte communication that's come to light thus far. Glanville, lawyers Love and Hylton, look, he didn't even capitalize. He didn't even capitalize Love that time. Infected the process of Williams' trial and have illegally poisoned same forever. Judge Glanville had the ethical duty to recuse himself sua sponte once he had these ex parte communications. However, neither Glanville nor Love nor Hylton uttered a word that they had spent the morning of June 10th leaning on Copeland to testify for the prosecution, coaching Bumpus on what to say and how to sell Copeland on the proposition, caused him to testify against Mr. Williams, coaching Mr. Copeland on how to deliver his testimony, promising Copeland that he would not be prosecuted even for perjured testimony unless he told a bold-faced whopper. Now, we know this. We know this to be true because we read even a partial transcript showed a lot of this. This is misconduct. Public officials heard and failed to reveal that Copeland confessed to committing every indicted offense in this case. Even non-lawyers can see Glanville, Love, and Hylton are not acting in an ethical manner, are on the same prosecutorial team, and Glanville should not be rewarded with the opportunity to continue to preside as judge over Williams' trial. In reality, Glanville, Love, and Hylton have made themselves witnesses who counsel will call. They must be recused. Y'all, do you think, just like, when he says even non-lawyers, I'm like, did he come watch my video and get in my comments? Did he come see what y'all are saying about this? Like, because we know they're on YouTube because they're citing the Law and Crime, right? Like they put a link to Law and Crime in there. So like, I'm like, oh, do they know that I have the greatest chat in the entire internet? Do they know that? Probably not, but. Kayway said, still going to Denzel and training day on these cases. And you're right about that. Okay, y'all remember when Miss Bennett was on the stand? She had said Hamilton told her he has the judge in his pocket. Oh, I don't remember that, but that's a good point, Nia. Wow. I will never go to Fulton. Laws don't apply to everyone except the poor. Okay. Well, I'm going to go to Fulton County. I'm going to go meet you guys on the 13th of August. Okay. Back to work. Sorry, I get distracted so easily. It's important to note that Glanville originally denied Williams' request for access to the ex parte transcript, keeping contents of the record totally hidden by Love, Hylton, and Glanville. Fortunately, mounting pressure related to Glanville's gross misconduct, violation of his oath of office, ethical violations, and potential criminal conduct by Love and Hylton and Glanville worked to effect change. Still going hard, you guys. Oh my God. Oh shit. Sorry. I love it. It's too much. Okay, Brownie, I'm glad you like it. Let me show you the back. Let me show you the back, guys. Oh, wait, hold on. That's not here. It's got the OG Cadillac Lady Justice. We're going to have the merch store, like, ready to go. There's some stuff in there. If you want to go, check it out. Feel free. But we want to do like an official formal launch, okay? So, we will get that. Yes, Denise, I did get the new computer and new camera hooked up. Thank you. I'm glad you could tell. I'm so glad. You guys are the best. Okay. On Monday, June 17th, 2024, Glanville denied undersigned counsel's motion to recuse and went forward with trial on this case. Similarly, he denied Weinstein's motion to recuse on June 12th. He then continued to unlawfully preside over Williams' jury trial. He must be removed and has been proven to have actual bias as well as an appearance of bias. I agree with that. Like, we've been saying that all along, right? Like, remember, Miss Love would make an objection and it would be wrong, and then the judge would tell her what the right... I have definitely had judges tell me the right objection. Okay. But then you know they like your side better. Excuse me. My awesome new tumbler. You guys are the absolute coolest. You guys are the best. Thank you so much. Okay. Here we go. Keep going. Counsel has never been afforded the questions that Hylton or Love created to give Copeland. Okay, remember, the judge was like, well, just give him a list of the questions you're going to ask him. Counsel has never been given this list, even though Glanville had been made aware of these questions and encouraged Bumpus and Copeland to review the questions. The question must be asked, why Judge Glanville has ex parte access to Hylton and Love's questions for a witness. This conduct is beyond repair. Glanville, Hylton, and Love did not give a hint that they were meeting ex parte with witness Copeland on Monday, June 10th, or any time. Undersigned counsel had no idea that Glanville, Love, and Hylton would dodge the law and ethical rules to conduct this improper and unethical ex parte conference. Glanville and lawyers Love and Hylton were duty-bound to immediately announce Mr. Williams' counsel and all the accused counsel that this meeting occurred. Brady evidence was obtained and the transcript was made and allowed argument to flow. Instead, their cover-up equals their misdeeds. Y'all, oh, I have my fan. Okay, Steele. Okay, Steele. Nikki, thank you so much for the $1.99 super chat. I appreciate you. Everything you guys contribute does help me get better equipment, so I appreciate it. And soon, better lighting. I'm sorry my glasses have glare. Sorry you can't see my beautiful eyes. I think I look cuter with the glasses anyhow. This is me when I'm reading Steel. Like, this motion. It's making me hot. Glanville, Love, and Hylton, acting in concert, hid Brady evidence and attempted to normalize this unconstitutional Star Chamber meeting, unethical conduct, and witness intimidation by deflecting the focus on how undersigned counsel learned of the secret proceeding. Judge Glanville held undersigned counsel in contempt of court. This misconduct by Judge Glanville, Judge Glanville, lawyer Love, and Hylton undermines the trust in judges and prosecutors and cannot stand and cannot be rewarded. Action must occur in order to attempt to remove this dark cloud over Mr. Williams' trial and the criminal justice system at large. I love that. I love that. The conduct of Love, Hylton, and Judge Glanville can never be forgotten, normalized, or ratified. Wow, he's like bringing in the never forgotten. Like, that's like the 9/11 theme or something. Like, he's getting really top level dramatic, and I am here for it. I love it. The Georgia courts have always safeguarded and separated prosecutors and their duties from judges and their duties. There is no daylight between Glanville and his lawyer Love, and Hylton's improper and unethical conduct. All must be removed from Williams' case. As stated herein, Williams intends to call Glanville as a witness at trial, as well as this recusal motion's evidentiary hearing based upon his improper conduct and the need to make a further record to protect Williams' constitutional rights. Specifically, there appear to be communications not captured on the transcript. Lawyers Love and Hylton and Glanville's examinations are needed to complete the record. Does seem like there was a bit of a gap in the record, didn't it? Glanville is a necessary witness in Williams' trial, and his name will be used when undersigned counsel cross-examines Copeland when asking whether Glanville pressured Copeland to testify, whether Copeland realized that Glanville was allowing wrong propositions of law to be explained to him, and the fact that Glanville condoned Mr. Copeland lying under oath unless it was a bold-faced bluffer. That's totally illegal, by the way. Completely illegal. Okay. This mandate Judge Glanville not be in the courtroom in front of Williams' jury ever again as judge. Judges must be disqualified in proceedings in which their impartiality may be reasonably questioned, including not limited to instance where the judge is likely to be a material witness in the proceeding. Okay, Steele. Woo! Are we anywhere near done? No. We're not even near done. Grounds for recusal are contained in here. The judge should disqualify for bias against the party if such bias stems from extrajudicial source and results from an opinion on the merits on some basis other than what the judge learned from participants in the case. Ooh, right there. That's the key word. On merits other than what the judge learned from his participation in the case. That's why you can't have ex parte meetings. I roll my eyes because it's like, duh, I cannot believe these are grown people. I cannot believe these are licensed attorneys. I cannot believe that I am having to read these motions to you. I can't believe that this Friday morning is being spent reading these motions instead of going over witness evidence and testimony. It's just crazy. It's unbelievable. Okay, Black Butterfly, thank you so much for the $5 super chat. Glanville let Love get him jammed up. The whole meeting was her dumb idea. Okay, it was. And Glanville cannot say no to Miss Love. I do not know what information she has on that man. I do not know. The alleged bias of the judge must be such nature and intensity to prevent Williams from obtaining a trial uninfluenced by the judge's bias. In the case at bar, it's impossible to honestly find Glanville as impartial, fair jurist. A judge must avoid impropriety. It's so many words, you guys. Thank you for bearing with me. Okay, you guys are the best. Judges shall disqualify themselves in proceedings which their impartiality might be reasonably questioned. The fact that Glanville's impartiality might reasonably be questioned is grounds to mandate that he's removed from this case. I mean, it's not might reasonably at this point. It is absolutely being questioned, and more than reasonable, very, very reasonable. Commentary explains this. Impartiality might be reasonably questioned. Means a reasonable perception of lack of impartiality by a judge held by a fair-minded and impartial person. Oh, that's not me. Based on objective fact or reasonable inference. That might be some of you guys, but I am not impartial. I am very anti-government. I'm very biased against the government. There's no doubt. If there's a chance for me to think the government is messing up, I will. All right. The Code of Judicial Conduct mandates a judge step down from presiding over a case where he's likely to be a real and essential witness. Okay. Okay, the bias of Judge Glanville is of such nature and intensity to prevent Williams from obtaining a trial free from Glanville's bias and prejudgment. Prejudice, bias, or prejudgment, even in the exhibition of partisan feeling, is present in Mr. Williams' case, and Glanville should be removed instanter. Williams asked this court to hold an evidentiary hearing on this motion to recuse in order for Mr. Williams to gain a full understanding of the misconduct of lawyer Love, Hylton, and Glanville through the case. Glanville is so involved in this controversy that he objectively can reasonably be questioned, and he must be removed as the judge. Facts are so clear that Glanville, in order to shield himself from his co-prosecutors from the truth of their misconduct, denied Williams' motion to recuse without a hearing, without providing the transcript, and without permitting another court to hear it. This demonstrates that the Glanville is involved in this controversy. Think he's right. Think he's right. This is a pretty good demonstration. Eva, thank you so much for the $10 super chat. I appreciate you so much. Y'all are the best. Y'all are truly the absolute best. Thank you. Thank you, guys. Okay, significantly, Glanville is required to avoid not just impropriety, but the appearance of impropriety. This is because public confidence in and respect for the judiciary and courts must be maintained. As shown in Exhibit A, the shocking conduct of Love, Hylton, and Glanville provides bias and prejudice have been shown, and it would be an error for Glanville to continue on Williams' case. It has been held to be elementary that a judge must be disqualified when he's going to be a witness in the same proceeding. I mean, that's like a big fat duh, right? Imagine this, the judge is getting divorced, and then the judge is the judge, but they're like also, come on, that's not going to happen, right? Thank you, Simply. Thank you, everyone, for being here. I really appreciate you. In this case, sub judice, we're going to look this up together, guys. Under a judge. Oh, okay. Oh, okay. Look, I don't know about y'all. I love learning new things, okay? And anytime I'm reading and I see like a word or something I don't understand, I go look it up. That's how I have a good vocabulary. That's why I have a large vocabulary, because I will look shit up. Now, sometimes I won't remember it for my own use. I tend to speak very simply. I tend to like not use a ton of, but I have some big words I use, but not a lot. But I like to be able to understand it when I'm reading it. So I highly suggest the same to you. If you're going along reading something, you see something like, what does that word mean? Just Google it, guys. We got Google in our hands now. Like, we literally walk around with a machine that has like every answer to every question except what is the meaning of life. So just look it up. Like we just did here. That didn't take us long. Now we knew something. Now we know something new. In this case, sub judice, so under judge, Glanville has taken on prosecutorial role against Mr. Williams and hence must be recused. Okay. Glanville attempted to cover up. I kind of feel like at this point we're kind of repeating ourselves. Like, okay, we've had 39 paragraphs. Like, it was really good. We hit some bombs. Like, let's move along. Attempted to cover up his misconduct by intimidating undersigned counsel and then holding him in contempt, sentencing him to the maximum number of days to serve in custody for doing nothing but zealously and ethically upholding his professional responsibilities. He then took action before the jury after recusal motions were timely filed by the Honorable Douglas Weinstein as well as undersigned counsel. All of these actions taken by Glanville after these ripe and valid recusal motions were filed are void. Glanville has caused Mr. Williams immeasurable suffering and prejudice based on his love, and Hylton's denial of his statutory and constitutional rights stated herein. He must be granted a reasonable bond, and his statutory right to a speedy trial has been totally upended by lawyer Love, Hylton, and Glanville, and he must be cleared of all baseless charges. As spelled out above, this supplement to motion to recuse is timely, blah, blah, blah. The affidavit supports the recusal motion by giving fair support to the charge that Glanville's bent of mind may prevent or impede impartiality, as required for Judge Glanville to preside over this case. Glanville's extrajudicial misconduct cannot be ignored. Love, Hylton have worked in lockstep to ensure Williams' constitutional and statutory right to a fair trial, impartial tribunal, due process, right to be present, as well as the Georgia Constitution, right to cross-examine, present a defense, effective assistance in counsel, right to assist his counsel, all have been crushed. This trial is a farce. Denying this motion to recuse and permitting Glanville to continue as judge perpetuates injustice. This case can never return to constitutional normalcy based solely upon the improper conduct of Love, Hylton, and Glanville. Any tragic conviction and sentence in this case will likely be reversed. Glanville has made himself a necessary witness, as has Love and Hylton. Should Glanville not recuse, Mr. Williams would be prevented from exercising his constitutional right to call witness, and Mr. Williams needs to show the jury why Love and Hylton and Glanville were not just doing their jobs, but were teaming up with a unified front to convict him. Once armed with this evidence, the jury can then properly determine what, if any, of this testimony and these facts will bear on their verdicts. Glanville must be removed. I kind of wish they ended every paragraph with that. I would. That's the kind of like dramatic writing I like to do. Just like repeat the same. Glanville must be removed. Glanville must be removed. Mr. Williams' motion to recuse an affidavit, timely file, require to answer legal question as to whether motion meets the threshold requirements. This is simply a question of law. Glanville, acting way outside the parameters of fair impartial jurists, denied the motion, finding that it did not meet the simple threshold requirements. Williams' motion and the attached affidavit clearly met the threshold requirements. This ruling clearly shows bias on Glanville. By Monday, July 1st, Glanville allowed undersigned counsel's motion to be forwarded to another court. Mike White, thank you so much for the $4.99 super chat. I appreciate you. He says nothing stronger than U.S. Steel. YSL Steel coming in strong and hot. Okay. While it shows that there's at least a reasonable appearance of impropriety by Judge Glanville, judges shall disqualify themselves from any proceeding in which their impartiality might reasonably be questioned. Judges shall perform judicial duties without bias or prejudice, and shall not, in the performance of duties, by words of conduct, manifest bias or prejudice. Judges shall be faithful to the law and maintain professional confidence in it. Glanville has violated all of these critical and worthy principles. He had the duty to act at all times in a manner that promotes public confidence to the impartiality of the judiciary. And he didn't, did he? Glanville has abrogated his duty. A hearing must be here to properly document the misconduct between Love, Hylton, and Glanville. A full evidentiary hearing must be conducted where Love, Hylton, and Glanville be called as witnesses to determine the nature and scope of their relationship and misconduct. Man, I really hope that we get to hear that hearing. I really hope there's an evidentiary hearing and we get to watch it. Ooh, that's gonna be good. Before the jury, Glanville will be spoken about in terms of his work as a member of the prosecution team. Glanville will be called as a witness. The law mandates that Glanville be removed from presiding over his case because he cannot be a witness and a judge. He has given them all legal advice, and they should all have separate and distinct roles in the legal system. The distinction between these roles has been washed away in Williams' case. When the judge instructs Williams' jury that by no comment, ruling, or action taken by the trial court should the jury determine that the judge has any bias in favor of a party. This will be a disputed point of law. Williams will be calling Judge Glanville, Hylton, and Love as witnesses, and thus this instruction does not apply to Mr. Williams' case. In Mr. Williams' case, the conduct of these three lawyers when examining the evidence and evaluating the instruction. Glanville is a necessary witness. As attested to in A, Glanville got extrajudicial information and gave opinions and legal advice that included, but are not limited to, Copeland went to prison for crimes committed on behalf of YSL. Williams and other co-indictees know Copeland and his criminal conduct that is not known to the judge. Copeland could be cross-examined on his other crime evidence because William and the co-indictees have far greater knowledge of Mr. Copeland and his background than others, and the like. By embracing this extrajudicial information, which the judge did. Remember, the judge was like, well, we don't know what, they know far more than you. And he was talking about defense. They know far more. Like, okay, Glanville. So, when Glanville said all of those things, where did he get that information? He could only have gotten that information extrajudicially because none of that had been brought up by a witness in court yet. So it's not like a witness had said those things. So clearly Glanville got information from the outside of that courtroom. Glanville's derogatory and prejudicial statements and demeanor must be considered by the Honorable Court. Glanville has an ethical duty to disqualify himself. Glanville has violated his oath and not voluntarily disqualifying himself. And the lawyers have manufactured an unfair, unconstitutional, broken trial and caused Mr. Williams severe prejudice by incarceration for over 2 years without bond and a laughable trial that has lasted entirely too long with the games played by Love, Hylton, and Glanville. Glanville must be removed instanter. Hold on, I need to catch my breath. So hard to read so much out loud. Okay, let's see. Hi, Eric, a Florida criminal defense attorney that found my channel. I'm glad. Thank you, Eric. Enjoying how you read the motions with emphasis and not monotone. Thank you. I couldn't do anything monotone if I died trying. I really appreciate that. Thank you. Welcome. Oh, I guess E. Erickson. I just assumed your name was Eric. All right. So thank you and welcome. D says, just got on. When Steele said DA stood there and did nothing, judge put Steele in holding. Didn't Love say they would be like confer on what his punishment should be? I don't remember her doing that. I think Love sat there silently. As I recall, she just sat there and shut the F up. Jiggy said, Woody got asked, what's your favorite type of cheese? And then started laughing and said, I am about to troll myself. Got the question repeated on him and then pulled out a thick money roll. Where was that? Woody has just been doing too much, you guys. He is just out here doing too much. My goodness. Okay. Sorry. I'm sorry. Woody is just, he's so funny. He's like went from like witness, and like, we haven't seen this with any of the other. Remember Adrian Bean, No Ma'am, Mr. Adrian Bean, and like Tick, they had not done what Woody has done. Woody is acting a fool, running amok, y'all. Woody is just out here having the most fun at the expense of the I'm going to say the Fulton County judicial system, not the entire judicial system, but I might be wrong. He might be having fun at the expense of the entire judicial system at this point. I mean, I swear to God, he makes me, everything I hear about him, it just makes me laugh. Like, it's so silly. That's a sworn witness, y'all. I don't think we'll come back. I don't think this trial's coming back now. At this point, I don't think trial's coming back. Okay, the instances herein, as well as Exhibit A, represent more than mere friction between zealous counsel and a diligent jurist. Which, there's sometimes friction between the lawyer and the judge. The judge makes ruling you don't like, whatever. Glanville's conduct created the realistic impression that he has harbored an inclination to be biased against Williams and partial towards Love and Hylton. Although proven, this honorable court need not decide whether such bias or impartiality actually existed, because Glanville was ethically bound to disqualify himself whenever this impartiality might be reasonably questioned, including instances where his behavior could indicate that he had a personal bias against or prejudice against a party or party's lawyer. Glanville's impartiality is more than questionable, and it's error to permit him to continue on Mr. Williams' trial. As shown herein and in the attached affidavit, Glanville is disqualified from any contact with this case moving forward based upon his bias for Mr. Williams and or counsel, which stems, in part, from extrajudicial sources and results in opinion on the merits or some basis other than what Glanville learned in his lawful participation of this case. We have what we call prima facie, that means on its face, prima facie evidence that that's the case in the transcript. The transcript talks about, oh, well, Woody has this whole history and the defendants know so much about history. Where the fuck would the judge get that? Where did the judge get that information, if not from TV, newspapers, the lawyers, judicially? Getting tongue-tied, y'all. This is a long motion. It's really good. It's a long motion. Gene said Woody had a short that said he just opened his first checking account. That's what I'm talking about, y'all. Like, Woody. Silly. Okay, as cited above, ex parte communications are presumptively harmful error. State has the burden of rebutting the presumption. That paragraph just repeats everything I've said 400 times. Judge Glanville, Hylton, and Love have goaded Mr. Williams into moving for mistrial. All of the conduct and proceedings after Douglas Weinstein, as well as undersigned counsel, filed a motion to recuse and affidavits are deemed invalid and have no effect. Well, he's asking they be deemed invalid. He's saying they should be deemed invalid. He doesn't actually get to decide that. Attached affidavit sets forth the facts. Allegations are definitive and specific as to time, place, and detail as to the extrajudicial conduct or statements which demonstrate both bias in favor of Love and Hylton and their position on behalf of the DA and prejudice towards Williams and his counsel. Moreover, there has been a systematic pattern of prejudicial conduct towards William and his counsel and other co-indictees and their counsel by Glanville, Love, Hylton, acting together unethically, which has influenced the trial process and has broken the foundation of a fair trial. These are not bare conclusions or opinions, as Glanville has attempted to claim after Williams timely filed his motion to recuse. Instead, Glanville was using his position of power and trust to obstruct justice and has violated his oath of office while lawyer Love and Hylton sat mute as they violated their oath of office and ethical responsibilities to ensure a constitutionally fair trial. Love, Hylton, and Glanville must be disqualified. And then he says, release Williams. I think if a new judge gets assigned, which a new judge should be assigned, then that judge will get to hear bond motions, and maybe they'll let Williams out and let him walk into the courtroom like they did Karen Reed. As explained above, ex parte communications are presumed error. State has to overcome it. Their conduct is reprehensible. Glanville has never affirmatively stated he has not considered these ex parte communications. Love and Hylton have never uttered a syllable denouncing these ex parte communications. Instead, they promote the propriety of these ex parte communications. State cannot refute this presumption of harm. Glanville had the duty to disqualify himself. We know, we've read that 8 times. The law requires the court to recuse. The public must believe in the absolute integrity and impartiality of judges. And guess what? If you've been watching this with me, we don't believe in that. Not out of this judge. We sure as shit don't believe out of this judge. Now, if you're one of us and you're here all the time, then you understand that one judge's action doesn't speak for every judge, right? But it's not a good look coming out of Fulton County. That is why, even without showing bias, prejudice, or unfairness, regardless of the merits, it's inappropriate for a judge to preside on action. Blah, blah, blah. I'm sorry, he just kind of starts to repeat himself quite a bit. Here, we'll get into the campaign thing. This honorable court must recuse itself from this case because refusing to do the same would permit questioning of this honorable court, something the court will not countenance. This court must recuse as well. An appearance of impropriety exists in situations where reasonable minds might perceive the honorable court's ability to carry out its responsibilities with impartiality and integrity or competence is impaired. Furthermore, this honorable court has received $2,000 donation to its re-election campaign from Glanville in April during the pendency of Williams' trial. Ooh, so like she got the money, like, wow, this trial is going on. Like this April, like 3 months ago, April. Man, can you believe April was already 3 months ago? Time is flying fast. Glanville giving this contribution could be deemed exceptionally large campaign contribution, and another reason this court must recuse. Okay. And it's signed by YSL Steele and YSL Adams. Okay, just let me take a few second break. Just give me a second to relax. Let me drink a little water before we get into this exhibit. Now would be a good time to say thank you everyone for being here. Make sure you hit like or subscribe, please. For those of you who've done super chats today, thank you so much. Everyone who's contributed Cashapp and these beautiful gifts, I appreciate you all so much. Okay. It's just so much reading, y'all. But I'm happy to do it. I love you guys, so I'm happy to do it. All right. We're gonna start here. Affiants hereby expressly adopt and embrace all statements made by the motion to recuse and joint affidavit attached and rely on the timely filed and asserted motion as well as the affidavit herein. Glanville met with love, bump it. Okay. Remember I said he's lowercasing lawyer love, but look at this. The Honorable Attorney Bumpus. All caps. Honorable Attorney. Whereas we have Lawyer Love and Lawyer Hylton. Y'all, Lawyer Shane is so silly. I'm not going to capitalize the word. I'm going to call you lawyer, and she's going to be an honorable attorney. I love it. I love it. Oh my God, I just love it. Okay. Sorry, I'm still laughing. I love it. I love the lawyer shade, man. It's so petty, right? It is like that subtle, it's like next level, but it's like so subtle petty, and like you only know if it's petty if you're a lawyer, right? Like, or if I've told you. So it's like that next level, like detail minutia petty. I'm all about that. I am about that, okay? All right. The court reporter, sworn witness Copeland, members of the DA office, including investigators Long and Hamilton, as well as members of the county sheriff department, outside of Williams and his counsel present, and discuss critical parts of Williams' case in violation of Williams' constitutional rights to a fair tribunal, right to be present, so on and so forth. Oh, Red Bunny, thank you so much for the $4.99 super chat. I appreciate you. I appreciate you so much. Red Bunny is always here, y'all. She's amazing. Thank you. Oh, look, I've gone the whole morning without singing yet, y'all. It's been like an hour and 15 minutes, and I haven't even sang yet. I almost started singing just then. The purpose of this ex parte meeting between Love, Hylton, and Judge was to act in unison in order to influence sworn witness Copeland to testify against Williams. There was no lawful purpose for this hearing to occur. There was no allegation by Copeland that he was somehow threatened. There was no allegation that he was not satisfied with counsel. And there was no allegation that he needed to meet with Glanville. Instead, this meeting was orchestrated by Love, Hylton, and Glanville to convince Copeland to testify against Williams. Influencing a witness meeting eviscerated any appearance of regularity in the tribunal and demonstrates at the very least Glanville is biased for the prosecution and against Williams. Man, eviscerated? Yeah. Lawyer Love begins this unethical ex parte conference by explaining that the state's reason for Glanville to meet with sworn witness Copeland is to impress upon Copeland that he needs to testify for the same reasons Love announced in open court on Friday, June 7th. The Honorable Jonathan Melnick that Melnick abandoned his client. At this point, rather than acting as a true judge, protecting our court system and its reputation by questioning, why am I meeting ex parte, and why am I being used to answer in front of the only members of the state of Georgia questions for Mr. Copeland? Glanville, because he's biased, agreed to help convince Copeland to testify adverse to the liberty of Mr. Williams. Yes, this is absolutely a dumpster fire trial. I am with you, E. Erickson. It is shocking to watch. I've said you're new, but in the weeks past, I've said we read about this in law school, but we read about this stuff like past. Like this happened in Jim Crow era. This is not 2024 shit, right? This is not 2024 judge behavior. And yet, here we are in the year of our Lord, 2024, literally watching it together. Crazy. Lawyer Love made untruthful statements about email correspondence with the Honorable Melnick. She sure did. Love continues to make false representation, and Glanville knows, if he has paid attention at all during the proceedings, that Love makes intentional misstatements of fact routinely. Yet Love deflects her misconduct and cites the ethical rules of conduct for attorneys during this ex parte meeting. Oh, the irony. Love explains the need for ex parte communication. All that aside, we'd like the opportunity for the court to address Mr. Copeland with Mr. Copeland's standing counsel present, to allow Bumpus an opportunity to explain to Copeland everything that I've just said. Again, Glanville has thrown away all appearance of propriety in permitting this ex parte meeting to occur, and at the behest of Lawyer Love and or Hylton, Glanville is not independent and is being led by the nose by members of the Fulton County DA. This is because Glanville is a member of prosecution team. I feel like led by the nose is kind of the most perfect way to describe Glanville's behavior as it comes to Love. And we've talked about this. Miss Love is running Glanville's courtroom. He defers to her. He let her run the ex parte meeting. He let her run the ex parte meeting. So she is leading by the nose, no doubt. No doubt. Yeah, tall glass. This was side work for Steele. He still has to prepare and get ready and be ready for trial. Crazy. Glanville then adopts the wrong law offered by Love that Copeland will be held in custody until he testifies. Love seems to somehow assert that Copeland can be kept in custody even after Williams' jury is discharged. Objectively, Glanville permits several misstatements of law in order to have Mr. Copeland testify against Mr. Williams in order to assist prosecution. Well, I call her lying Love for a reason, y'all, because we know she's lying. We see her lying in the courtroom all the time. Love be lying, okay? And so I've been calling her lying Love for months now. Finally, it's called out on paper, right? Like, finally, somebody is pointing it out on paper that this woman keeps lying. Oh, boss says Love is actually bigger than Glanville. Maybe he's just scared of her 6'4" self. K-Way says, if you're in school, it still gave you a referral, you're getting an ass whooping when you get home. No doubt. Okay. Glanville becomes an advocate for Copeland to testify against Williams by telling Bumpus how to communicate with her client. Specifically, that Copeland is gonna face some significant cross-examination. And Judge explains to Attorney Bumpus that this is it's all in the message and the packaging in terms of, I think Mr. Copeland is, a savvy person. But, he's certainly going to be subject to a thorough and sifting cross. The fact that Judge Glanville is dispensing legal advice and strategies to Attorney Bumpus, guiding her on how to speak with Mr. Copeland in order to have her client testify against Williams, is a clear, direct fact that Glanville has forfeited his judicial role. Forfeited his judicial role. All right, Glanville, along with lawyer Love, continues to advise Bumpus as to what to tell her clients. For instance, part of the challenge, maybe you need to ensure Copeland, look, I'm going to be there. And if you think they're asking you a question, they being state or defense, is asking you a question that's going to bring out other crimes that you're going to be able to look to you and say, can I have a chance to talk with you? Lawyer Love, who's working in lockstep with Judge Glanville, states that's exactly right. Lawyer Love then inaccurately bashes Attorney Melnick by saying the biggest concern is Copeland's best interest and they're just not here. There's no reason that Judge Glanville and Love are discussing what Attorney Bumpus should be telling her client, and no reason for Judge Glanville to permit Love to ridicule Melnick. Wow. Love again misrepresents by claiming that Honorable Attorney Melnick has been talking to Steele and Shard. That's it, he's not talking to us. Why does Glanville hold this ex parte conference and permit lawyer Love to falsely accuse Affiant and the Honorable Attorney Maxwell Shard of obstruction and ethical violations by influencing a lawyer-client relationship? This is extrajudicial information that Glanville should never have received. Boom. Glanville continued to be a prosecutor of Williams when he instructs Attorney Bumpus that the sworn witness Copeland can invoke the Fifth Amendment if he testifies about an unrelated crime. Glanville tells Bumpus that sworn witness Copeland is probably thinking about, there's a lot of stuff the defense could ask about that's not known to a lot of people. Copeland could invoke the Fifth Amendment if it was some other particular crime. During this advice on what to explain to Mr. Copeland, lawyer Love and Judge Glanville are speaking with one voice. This has Judge Glanville presuming and pontificating that Mr. Copeland is involved in a lot of unrelated crimes, that Mr. Williams, a criminal himself, is aware of the same. Glanville, like the jury, is only supposed to look at what is in front of him. Now, unlike the jury, he gets to see every piece of evidence and decide whether or not the jury gets to see it. But he can only be making rulings and decisions about the evidence that's based, in front of him. Okay, wait, someone is saying the recusal was denied. Bolin, if you're here, I need you to look that up. This great bias cannot be more clear than when Glanville explains to Bumpus that she needs to give sworn witness Copeland the questions that the state is going to ask him if he testifies, and to ask Mr. Copeland to tell Attorney Bumpus any other facts that they might ask about. Further, as long as Attorney Bumpus has knowledge of other crimes that sworn witness Copeland has committed, Glanville states that Copeland will be fine because the state is only going to get in questions that was provided to Copeland. It is ridiculous to claim that Glanville is not biased and impartial. Glanville continues explaining to Attorney Bumpus that the reason she needs to know from Copeland what crimes he has committed in the past, the defendants know more about Kenneth Copeland than anyone else, so they're probably gonna kind of. How does the judge know what the defendants know? How does the judge know what the defendants know? Unless somebody told the judge outside the courtroom. What gives Judge Glanville the right to state Mr. Williams knows more about Copeland's supposed bad conduct than anyone else? In reality, Mr. Williams hardly knows Mr. Copeland. Judge Glanville has pronounced guilt on Mr. Williams. Judge Glanville imparts legal direction to Attorney Bumpus on how to prepare Copeland for cross-examination and how to prepare Attorney Bumpus to object on behalf of Copeland. Glanville has tarnished his trial forever, and Williams could never have a fair trial the way Glanville has acted, both in front of the jury and outside everyone's presence in ex parte meetings. The conduct of Judge Glanville, Lawyer Love, and Lawyer Hylton has caused them to be necessary witnesses at trial. Affiant intends to call witnesses and cross-examine Glanville, Hylton, and Love on how many ex parte meetings the three of them and any other members of the prosecution team have had. Glanville cannot be judge and witness in the same proceeding. Love and Glanville, acting in concert, tell Bumpus that Copeland can cancel legal representation because Love and Hylton and Judge have done everything to ... clear Copeland of judicial exposure. It's a good point. That is such a good point. Man, I love my new Tumblr. It's so cool. Okay. Without any reason to believe that Copeland might be fearful for his personal safety, Glanville injects the safety concern as a hypothetical reason. Remember, we talked about that when I read this out to you. I was like, oh look, the judge brought up the safety, and he's probably going to use that as his defense. Love misrepresenting emails continues the theme of Copeland's personal safety. There is no evidence of the same. Glanville tells Bumpus that Copeland has to give testimony. That's what he has to do. He's got to give the testimony, whatever it is, good, bad, and indifferent. The question must be asked, why does Copeland have to give testimony? Is it because it favors the prosecution? Whose vantage point does Judge Glanville view this trial as good, bad, or indifferent? To whose position? Glanville must be recused. So I love these questions. To whom is it good, bad, or indifferent? You're talking about you need to testify good, bad, or indifferent. To whom? That does show bias. I mean, when we went through this, I was reading it. I didn't make this whole analysis deeply, line by line, the way Steele did. Steele ate this transcript apart, okay? And each line he had a note about what type of issue what this was. Is this the judge? Is this what law did this break, right? And he's done a damn good job, y'all. He has done a good job. Okay. Glanville has the audacity to bring sworn witness Copeland into his chambers without request of Bumpus, but at the request of Love. From 9:34 until 10:30 a.m. or 10:03, nothing is recorded by the court reporter. Affiant will call Love, Hylton, and Glanville to probe what happened during this time period. Once in custody, represented by counsel, sworn witness Copeland is brought involuntarily to Glanville's chambers. Glanville explains, I wanted you to bring you over and let you talk with Bumpus and see if there's anything you need to ask of your counsel, Miss Hylton, or the state or court before we bring you out this morning, because we would like to hear your testimony. It is kind of where we are at this point in time. It's hard to articulate how wrong this ex parte summit is and how obvious it is that Glanville discharged the sanctity of judiciary to become part of the prosecution team. Glanville is biased in this case and the case is constitutionally broken because the conduct of Lawyer Love, Hylton, and another member of their team, Glanville. Why is Judge Glanville inviting Copeland, a represented party, to ask questions of Lawyer Hylton or other members of the DA or the court? This is beyond comprehension for an impartial, seasoned jurist to act. This is because Glanville is not acting as an impartial, seasoned jurist, but is part of the prosecution team and must be recused. Lawyer Hylton makes it clear that Copeland has never stated he has a safety concern which is stopping him from testifying. Hence, this whole safety concern discussed early was totally fabricated by Glanville and Love. Copeland says, "I've never been truthful a day in my life. Until I made this statement right now." This is quintessential Brady evidence. Judge Glanville never uttered a word, nor did Hylton or any member of Fulton County DA provide the defense notice of this Brady evidence. Same is unconscionable. Affiant intends to call Glanville as a witness to trial, as well as Hylton, to discuss the failure to reveal this information. The jury has a right to know that when a judge reads the instructions that the court has no interest in this case except for a fair trial. Same is not truthful, as Glanville is on the prosecution team. Glanville, Hylton, and Love will be called as witnesses and have been added to the witness list. The fact that these three people attempted to hide Brady evidence is beyond pale. Glanville instructed the jury he has no interest in the case except to see a fair trial. Same is untruthful, and the jurors need to hear from these three witnesses in order to make determination on whether the same was truthful or not. Lawyer Hylton gives inaccurate legal information on whether Copeland can be prosecuted at all, and gives some far-fetched idea about the federal statute of limitations and the state of Georgia statute of limitations. Glanville sits idly by and allows Hylton to misrepresent to sworn witness Copeland that he cannot be prosecuted for crimes. Anyone with a modest interest in this case would know that the prosecution has called Mr. Copeland an unindicted co-conspirator, and that the supposed RICO conspiracy statute of limitation continues today. Thus, Copeland could be prosecuted in both federal court and state of Georgia for crimes. This is wholly contrary to what Hylton and Glanville allowed Copeland to believe. You guys remember when we went through, do you remember when we went through the transcript and Hylton said, you know, you can't get charged, period. And I was like, we don't say period as lawyers, okay? There's no period. You don't just say period. You don't say things like that. Remember, I was so surprised that she would have talked that way. Because she shouldn't have. All right. Hylton and Glanville do not disclose other Brady evidence. As lawyer Hylton explains, the state can assist Copeland with finding different places to live. This is part of an agreement that should have been revealed pursuant to Gigolo. That was not done. Hylton is a witness and will be cross-examined. Hylton then tells Copeland, who at the time was a represented person, that he can speak with her without Bumpus present. Oh, Jean just gave 5 memberships, y'all. Y'all, this is amazing. Thank you, Jean, for gifting the 5 memberships. And everyone that got a free membership from Jean, please make sure you say thank you. Okay, this is amazing. Glanville did nothing to stop this potential unethical conduct. Hylton tells Copeland that he's immunized for prosecution, while Glanville sits silent. That statement is not true, as Copeland received only use immunity. However, Glanville reinforces lawyer Hylton's wrong information because he is a part of the prosecution team. Glanville tells Copeland that he will not be prosecuted for any crime. Glanville and lawyer Hylton are acting as one, not separately, as required by law. Glanville explains to Copeland that if he's worried about what defendants may ask you because they know your business, you can't be prosecuted for those. First, that's not true, since Copeland was only given use immunity to affiant's knowledge. However, it is clear that Glanville is an assistant to the prosecution because Glanville, in order to help the prosecution, needs Copeland to testify and gives Mr. Copeland advice about cross-examination. Importantly, Glanville again asserts that Williams and the other co-indictees may know your business, but if they ask you about things you might have some liability, you can't be prosecuted on any of those. This presumes that Mr. Williams knows Mr. Copeland's criminal endeavors, because Mr. Williams is a co-conspirator. Glanville is far from acting as an impartial judge. Copeland again puts an end to any made-up safety concerns and explains he does not want to testify because he will set a bad example for his family based on his past misdeeds. One must ask, why is this ex parte conference occurring, and why does it continue? The only logical answer is that Glanville, Hylton, and Love, acting in concert, had the agenda to ensure that Copeland testifies against Mr. Williams in order to convict Mr. Williams. This is the definition of biased judge and unethical prosecutors. This trial is constitutionally broken because of these three actors. Hylton never provided to affiant any Brady material that Copeland had told her in the past that he was a liar. Glanville sits mute and does not ask whether this Brady evidence was provided to affiant. Copeland explained he never told Hylton that the Honorable Attorney Melnick was not his lawyer, and thus lawyer Hylton met with a representative party. Remember, we talked about that. She said she knew by Thursday that Melnick was her lawyer. That's why they made the immunity. But then on Friday morning, she went and greeted Woody from the car without Melnick there. So she said she was going to do that. Like, or she's admitted to doing that. That's what I mean. We already have the evidence. I mean, it's prima facie evidence. She confessed. Idiot. Copeland explained he never told Hylton that Melnick was not his lawyer. Oh, okay. Hylton told Copeland that he would not be held in custody until every last defendant had been tried, not just the sixth, the other one too. Glanville sits mute and delegates his judicial discretion of punishment to lawyer Hylton because Copeland does not have to be housed in custody until every last defendant is tried. Glanville, like Hylton, attempts to intimidate Copeland by telling him that if he chooses not to testify, he'll be held in custody until all 12 co-indictees' cases come to an end. This is just not true. In fact, Glanville is not even the judge on the other co-indictees' cases, as same is being presided over by the Honorable Judge Dempsey. So these people are really threatening that Woody would have to be there through the entire trial of all of the defendants when the judge isn't even presiding over the trial of the other defendants. Where would he even get the jurisdiction? Unbelievable. Glanville and lawyer Hylton failed to reveal to affiant Copeland's statement that I told the police whatever different story I could think of to try to finesse my way out of the situation. Instead of turning over Brady evidence, Hylton, with the support of Glanville, explained to Copeland that he can simply testify, I don't recall. Glanville, Hylton, and Love are inseparable and biased against Williams. Glanville advocates for the DA's office when he tells Copeland, just tell the truth, while lawyer Hylton is telling Copeland, just tell the truth, and let lawyer Hylton worry about impeachment, and Mr. Copeland will not get in trouble. This excuses Mr. Copeland from giving false statements to law enforcement officers with the statute of limitations tolling provision. However, Judge Glanville tells Mr. Copeland not to worry about criminal violations as the commissions of same would not get Copeland in trouble. Seemingly, Glanville, Love, and Copeland spoke off the record as the judge recounts that, as Miss Love said this morning. Remember, Miss Love said if you lie, if you overtly lie about something, if you tell a bold-faced whopper, then they can indict you on that particular charge. Thus, Glanville and lawyer Love will be called as witnesses. So Glanville did, Love and Glanville met with Woody. There's no doubt. There's no doubt in my mind. Glanville sanctions a lie that is not a bold-faced whopper and has allowed Mr. Copeland then to seemingly lie about something that is not a bold-faced whopper. It's crazy. No, I was saying that. It's crazy. It's a fraud on the court. Crazy. Copeland states indirectly that if he confesses while testifying to murder, there is no statute of limitations for murder and he will be prosecuted. And Hylton said he will not be charged. Glanville sits mute during this exchange. Brady evidence never made its way to affiant by Glanville or lawyer Hylton or anyone else in the DA. Again, this is unforgivable. Moreover, when Copeland is speaking about murder, lawyer Hylton states that if she knows Mr. Copeland is lying, to wit, knowingly lying on material matter under oath in a judicial proceeding, i.e. perjury, Mr. Copeland would not be prosecuted for false statements. Again, this is Brady Gigolo evidence that Glanville and lawyer Hylton failed to review. Glanville is no longer acting as a person on the judiciary, but acting along with lawyer Hylton and lawyer Love in an impermissible matter. I swear, I can't remember the name of the case, but I swear in law school, in criminal procedure, we read about a judge, and the judge just said we, instead of, the judge did not do anywhere near what has happened here. But the judge said we in talking about the state, and that judge, everything was tossed because the judge said we. So this judge said we. This judge has said we a lot. So why is he still here? Y'all, I am going to need a comfort break here in about 4 seconds, okay? We're going to take a brief comfort break. I'm going to put this screen on and y'all read, and I will be right back and y'all read this paragraph. Oh, Jig Leo. Ha ha ha. Okay, I'm back. Sorry, y'all. We don't take 8-hour cover breaks here. Just quick. Okay. Ooh. Glanville sat silent as lawyer Hylton told Copeland he spent enough time in prison for YSL. This is extrajudicial information to Glanville that marks YSL as a criminal street gang a material element of counts in the indictment, including the count 1 RICO. This statement marks that persons supposedly associated with YSL are guilty of criminality. This entire illegal and unethical ex parte conversation was during a critical stage of the proceedings for which Mr. Williams was, as well as his counsel, had the constitutional right to be present based upon the United States Constitution as well as the Georgia Constitution. This Star Chamber meeting, oh shit, sorry guys, I'm like fiddling around with this thing under my desk. Sorry, I pushed the wrong button. All right. This Star Chamber meeting also violated Mr. Williams as well as his this Star Chamber meeting also violated Mr. Williams' right to be present, as well as the right to counsel, effective assistance in counsel, due process, fair trial, blah blah blah. Hylton explained to Copeland that no one here expects Copeland to remember every single detail from 2015. Which, I mean, I hope no one here expects any of us to remember every detail from 2015, because I don't think we can. Why is lawyer Hylton able to speak for Judge Glanville, who's present but silent? Is it because they're on one team? Oh, oops, that should have a question mark. Glanville has denied Williams of a fair trial and violated Williams' constitutional rights stated above and herein. Lawyer Hylton and Judge Glanville function as one cohesive engine, as shown clearly by the following. Copeland asks, "Can you give me house arrest?" Hylton answers, "No, you can go home by taking the stand and testifying. That's what Glanville then states, and come back tomorrow. Glanville allows Hylton to be the judge by telling Copeland that he cannot have time to think about whether he's going to testify or not testify, and that he can not be sentenced to house arrest but will remain in jail. This colloquy illustrates the fact that Hylton, Love, and Glanville are working together as one. Glanville has forfeited the right to be judge on Mr. Williams' case as he is biased. In fact, a fair judge does not have to keep a person who refuses to testify in jail. There are other punishments besides the same, including a fine, house arrest, or whatever else the judge deems appropriate. What legal right did Hylton have to pronounce punishment upon Copeland? Ooh, I just love the question. I love how he writes. Y'all, I love Steele. Steele has me like this. How he writes, oh my god. What? Ooh, it's so dramatic. Ooh, I love it so much. Okay. Thank you, everyone, for being here. Someone said, throw the whole trial away. I'm with you, Shoo Shoo. I'm with you. They should start putting some of these court cases on DraftKings. Oh my god, because that's hilarious. But I would actually, I don't think we can. I think that would be very bad, like constitutionally, like law-wise. But I definitely would totally bet on some of these trials. Totally. Completely. It'd be fun. Okay, Glanville fights for the prosecution by stressing to Copeland, they want your testimony. That's all they want, whatever it may be. Glanville is an advocate for the state. Why does Glanville tell a witness that the state wants his testimony and that's all they want? Why does Glanville care that the state wants it to witness testimony? That's not the concern of an unbiased judge. Love that. Hylton explained that Copeland will not be charged with perjury, although that is outside of the order of use immunity that was provided to affiant by judge. No Brady Giglio evidence was provided by Judge Glanville or lawyer Hylton. This is legally wrong. Hylton and Glanville misstate the law of perjury and give promises of no prosecution. Again, this is Giglio and Brady evidence, not revealed by Judge Glanville or lawyer Hylton, and in fact, same was hidden from Mr. Williams until Williams insisted on receiving this transcript. It's true. I mean, Brian Steele had to make a huge fuss in order for that transcript to even come out. Which, as you guys know, I think is crazy, because if you didn't do anything wrong, if the transcript's not a big deal, then let it out. Glanville and Hylton are necessary witnesses. Coupled with the early statements by Copeland about murder, which does not have a statute of limitations, Copeland is telegraphing that he is responsible for the indicted offenses. This critical exculpatory evidence was not given to affiant by lawyer Hylton, Love, or Glanville. In fact, it was hidden. Affiant will call Judge Glanville, blah, blah, blah. I feel like we've read that 800 times already. He is a necessary witness because he handed an unknown document to Copeland's attorney in Copeland's presence. They will cross-examine Glanville regarding why he gave an unknown document for Copeland. The jury needs to hear from Glanville so they can determine whether Williams has been given a fair trial by a detached, impartial jurist, as claimed by Glanville throughout the case. Hylton will be called as a witness because she, like Love, met with Bumpus for an unknown amount of time off the record. Affiant will examine lawyer Hylton on the promises she made Mr. Copeland and other witnesses in the past as well that are not revealed to affiant. Glanville and Hylton, working together, attempted to have Copeland dressed in civilian clothing to appear before the jury. Why would Judge Glanville care how the state's witness appears before the jury? This is specifically true since Judge Glanville did not do the same with an earlier witness, specifically Mr. White, who's testified in jail clothing. That's a really good point. You know, when we were going through this together, I hadn't thought about that, but they had, remember the one dude, Mr. White, they didn't show him because he was like currently incarcerated. I don't really know why they didn't show him. He was currently incarcerated. They had him up there in his outfit. He was the one who said, I don't know, I don't want to be here. I don't know, I don't want to be here. And he was one of the shortest witnesses we've had, or shortest time on the stand. I don't know how tall he was, but he was fully in jail clothes. I think he had like cuffs and everything. So what is so different about Copeland, and why is Glanville so zealously advocating to have Copeland testify? That's the real question. Okay. Glanville and Hylton speak for each other. Hylton answered Copeland's question on whether he would get locked up for this, and Hylton responded in front of Glanville, so long as you testify, we will get an order to get you released. Glanville remained silent as lawyer Hylton explained that we would obtain an order to have Copeland get released. Glanville and Hylton in love are all one. They handed a document. These are not the only times he's shown bias against Williams or his counsel. He initially refused to release the transcript on June 10th because he claimed it was privileged. Additionally, he must be recused automatically since he defended his position against Williams' motion to recuse. This honorable court, Krause, must also be recused because she sits on the Fulton County Superior Court bench alongside Glanville and has accepted his money for campaign. Signed, Brian Steele, Keith Adams. Okay, now the rest of the exhibits we've seen before because they are the transcript. So, like, we went through that before. All right. Now, so much, but it's such a good motion. Like, I'm like, damn, that's a really, really good motion. It's could have been a little shorter, but it is a good motion. All right, so that was what our dear friend YSL Steele was up to on Monday. On Tuesday, this was filed. Let me zoom. Too far. Ah! Sorry, guys. Okay. Y'all, just the title of this motion. The title of the motion is 1, 2, 3, 4, 5 lines long. You know it's serious when you come in with a 5-line title, bro. Motion for a fair trial, as well as a motion for a list of dates and persons who participated in any ex parte communications with the court and the topic of the same. Motion for mistrial based upon judicial and prosecutorial misconduct, and thus bar retrial. So freaking long. From its inception, the trial's been bad. Prior to opening statements, the court ordered all parties to share demonstrative aids that they would seek to display to the jury. Opening statements would begin on Monday the 27th, so objections could be made prior to presentation. On Friday, November 24th, Love shared her purported demonstrative aid via email. During opening statements, however, she showed a completely different, never-before-seen demonstrative aid, which was in clear violation of the court's order. The court denied the timely motion for mistrial, and there were no consequences for Miss Love's intentional misconduct. During the same opening statement, lawyer Love defied another court order by introducing to the jury that undersigned counsel had represented other people charged in this case. Specifically, during her PowerPoint presentation, lawyer Love highlighted to the jury that the undersigned counsel represented co-indictee Blaylock. Again, there were no consequences meted out by the court. Lawyer Love accused undersigned counsel of knowingly and intelligently misrepresenting the jury that witness Mr. Bean was taken to Grady Hospital by police from the scene. At bench conference, lawyer Love falsely stated she had evidence on her table to prove that counsel fabricated evidence as Mr. Bean never went to Grady Hospital. Her allegations were proven beyond any doubt to be false. Yet the court did not admonish Miss Love at all for falsely accusing another member of the bar for being untruthful. I'm just glad, I feel like it's taken forever, but I'm glad we finally have this motion out here about Love's misconduct. I don't know why it took so long. Like, what took so long? Okay. Over Williams' objection when the state was attempting to introduce the January 26, 2015 2019 social media post. From Garlington's account, during testimony of Gaither, Love told the court only Mr. Williams' voice could be heard on the video, except for one other voice saying "yeah" in the background. Cancel told the court the lawyer was incorrect and several persons' voices were audible on the social media. Love continued to falsely accuse undersigned counsel of misrepresentation of facts. Of course, Love was proven to be untruthful in her false allegations of wrongdoing against undersigned counsel. Although it was objectively proven that lawyer Love falsely accused another member of the bar of misconduct, the court did nothing to admonish her. This pattern of permitting prosecutorial misconduct illustrates the court wrongly favors lawyer Love. We've been saying that since the jump, y'all. Us trial geeks, y'all here watching my channel, we have been saying this since the jump. We said Miss Love has been running that judge. She has been running his courtroom. He's being pulled by the nose. On June 6th and June 7th, Love accused undersigned counsel of purposefully extracting and tampering with jail records. Remember, we went over that week, and I was like, why? She kept saying that Steele was trying to lie, and I'm like, I'm sure he literally just handed her what he got. This is another knowing, malicious, false allegation. The court remained mute and failed to admonish. On June 7th, she accused counsel for Copeland violating his ethical duty to his client, and the court remained silent by Love hurled more false accusations. And don't forget, she pushed Melnick out of the way with her ass. Big ass. Used it to slide him out of the way. He didn't even get to defend himself. In the jury's presence on separate occasions, the court wrongly accused undersigned of being unprofessional as well as unprepared. I was waiting for this. I thought this was going to be in the affidavit on the last motion, but it wasn't. So it's here. I was waiting for this. Both allegations are completely false, yet the court's bias is so deep that the court refused to instruct the jury that the court's declaration was completely wrong on both occasions, as undersigned counsel was neither unprofessional nor unprepared. The court's overly prejudicial and improper conduct towards Mr. Williams and his counsel, and his refusal to instruct the jury to disregard these impermissible and false allegations, as well as the court's failure to apologize for its baseless claims, proves bias for the state and against Williams. Okay, more law about needing to be recused. The court has done nothing to stop Love from continuing misrepresentations, abuse of others, and false allegations. Instead, on occasion, the court speaks in generalities and reminds both sides to be professional. This is not a both sides issue. This is a one-sided issue, resulting in prejudice to Williams and a violation to his fair trial. Williams languishes in jail without bond since arrest on May 9th, 22, and has been and is being denied his constitutional right to due process, fair tribunal. The court has exhibited a pattern of bias. Love engages in misconduct. The court has effectively joined the prosecution by permitting Love to defy court orders without consequence. The court has imposed no sanctions to stop or deter this prosecutorial misconduct. As a result, Williams has not received a constitutional mandated fair trial, and his due process rights have been shat on. All right, someone said go check footnote 3. Hold on. Footnote 3. Lawyer Love never introduced the evidence on her table. It's because she didn't have it. It's just bullshit. Liar. Lying Love. Here they had the ex parte meeting. To date, Williams has not been provided the state's motion to grant use immunity. Oh, that's crazy. How did they not provide a copy of the motion? That is crazy. Dear Nurse Life says, why aren't the other lawyers filing motions? There's power in numbers. I think it has to do with money. Like, I think Thug is like kind of, hey, I'm going to pay and you do the bulk of the work. And everyone gets their own lawyer, but that's what I think. I don't know, though. I can't answer. That would be speculation. More about the meeting. I'm sorry, I just can't read about the meeting anymore. Williams requests a list of persons involved, topic, transcript, etc. Now get rid of the lawyers and the judge. Okay. And here's a copy of the motion. All right. So that was Tuesday. Then on Wednesday, Steele filed this. This is his 8th amended list of witnesses. Okay, so this is his updated witness list. I never saw the first 7, so I can't tell you, like, are there big changes? Okay, but I want to point you out to number 16. Number 16 is Judge Uriel Glanville. Witness 16 is now Glanville. Oh, and look, 10 witnesses down right here. Simone Hylton. Witness 16 is Judge. Witness 26, Hylton. Ooh, I can't wait for Dora. Ooh. Keep going, keep going. And number 38, Adrian Love. So, he updated. Oh, Ashley Merchant's getting called. He updated this witness list. Steele went in. Steele wrote those motions. He did the affidavits. And then he said, these people are going to be added to the witness list. And they were. Beautiful. I love it. Hey, threats are totally empty and useless unless you follow through on them, right? So Steele said, I'm adding these people to the witness list. He added them to the mother trucking witness list. I love it. Oh, Debo says that the other lawyers don't have to respond because of the Harvey rule. And that Harvey rule really works out quite well in this case because a lot of the other folks don't have as much money as Williams. That Harvey rule, by the way, is a Georgia-specific rule. I don't know if we have a similar rule in Texas, but I know it wouldn't be called Harvey. Oh, yeah. But here it said that when Miss Bennett was up, Love told an open lie. She said it told her to kiss her ass. And Miss Bennett had the email, and it said for the judge to call her. It didn't say anything about kiss my ass. I think that's about the time I started giving her the nickname of Lion Love. I think that is about the time. Yeah, because, yeah. Cuzzo, I don't know why Hamilton isn't being investigated for sexual harassment. And I also like him to be investigated for his statements that he has the judge under control or whatever it was that's like, he's got that. That's his judge. Okay, so before I get into the late response from Miss Love, I want to first tell you a story about my childhood. Well, it lasted into my adulthood. All right. I realized at a certain point, you know, they were making us, I grew up at a time where we were handwriting stuff mostly. Then more and more computers were becoming available. More and more people would have computers in their home. So more and more we would be able to type our papers. Okay? Okay. This is the thing. I don't think, if anyone's out there that's a professor or teacher, listen to me clearly. I think it's a terrible idea to require a minimum page amount, okay? So anytime I had a professor that says, you know, you need to have at a minimum 10 pages or whatever, I think that's stupid. I believe the better goal would be to have less. I want concise and clear writing. Do not repeat yourself. Do not use, you know, lots of extra words that you don't need, etc. So I do think our teachers are wrong in that. So I like to write clearly and concisely, and I learned pretty early on in my typing, my homework assignments, that if I used Calibri body, I could get like 2 pages and not have to, like, I could type 6, like it was an 8-page requirement, I could type 6 in times and then switch it to Calibri, and then I would have 8. Okay, I learned that pretty early on. So I'd be loving that Calibri body when I don't have a lot to say on a topic, or I do have, but it's a concise, and so I don't have enough to fill the pages that this professor is saying to me that I need to fill. Okay, so that is my intro to Miss Love's response. This font is a font that you use when you don't have shit to say. This font is the font that you use when you don't have shit to say. I'm calling it Calibri body. I don't know that it's Calibri body. But this, yes, unpopular. It is a bigger font than Times, and it has a wider spacing between the letters. One of my favorite books as a lawyer for lawyering is called Typography for Lawyers. Okay, I'm gonna find it and put it in the box. This book right here, I'm telling you, this book is life-changing. Typography for Lawyers. So I got this book, I don't know, somebody gave it to me or something. And it's short. It's a short book, but it is fantastic. It really shows you, it shows examples. I wonder if I can see, like it would show you examples, right? Look at how this is written versus this, and what does that mean? Okay. Typography for Lawyers is why I use Palatino linotype. I either use Times New Roman or I use Palatino linotype, okay? Typography for Lawyers is why you don't write a response to a motion in Calibri body. Yes, Jiggy, that was my high school essay trick. That was my college essay trick. Okay, I thought it was so special. I thought I made it up. No, someone taught me about it, actually. We do not use APA, dear nurse. We have our own writing. We have the blue book. And in Texas, we have the green book. Okay. Mind you, this was due on Monday by 5 p.m. Love asked for 48-hour extension. Not 48-hour and 52-minute. 48-hour. But she filed it 52 minutes late. And going through this, just the fact that it's in Calibri means you know it shouldn't have taken no extra 48 hours. It should never have taken an extra 48 hours, let alone an extra 42 minutes on top of the 48 hours. It's in Calibri. She starts with an introduction. Now, I can't read this word for word. I've been reading to you guys for 2 hours straight. I am like, reading out loud out, okay? But, notice here, she has one footnote, one piece of case law. Remember, when we were looking at YSL Steels, by the time we got about here in the page, it was statutory law, constitutional law, case law. Boom. But not with Lie and Love. Not with Lie and Love. We have one case here. Okay. Oh, and then she lies. Right here. She does not even get 2 paragraphs deep before she fucking lies. The state recognizes that Glanville has assigned this motion and has been properly reassigned to this court, but the state respectfully submits that at time of reassignment, Glanville did not make the 3 requisite determinations. Bitch, he had already made these determinations. He went on the record on June 17th and he said these motions are timely. I ruled that these are timely. He said, I ruled that the affidavits are legally sufficient. does she think she's being slick when she writes at the time of reassignment? Does she think he needs to make that ruling again? Like he needs to like remake that ruling at the time he hands it off to someone? I do not understand. How can this bitch assert things like this? Is not only a record, we have it on TV. Everyone has links to the YouTube. I streamed this. And so you're going to make this assertion in your second paragraph, not first paragraph, second paragraph. She made it to the second paragraph. The audacity is so high. The state of Georgia, these employees, I swear to God. Okay, so this is her intro. Then she does a factual background. Okay. She talks about calling Copeland. Here on page 2, she cites some case law. Okay. Okay. Copeland, in preparation for trial, they met with Copeland on multiple occasions. He didn't say he was, he didn't say he had a lawyer. Okay, after receiving Melnick's email, the state presented to Glanville a motion to compel and extending immunity and to hold Copeland in contempt should he refuse to testify. So y'all knew he had a lawyer and you knew he was gonna refuse to testify. Now, mind you, no case law. Oh, sorry, she does OCGA. Okay, she does the statute. But this actually doesn't have anything to do with the issue at hand. This has to do with something else. This is a statute about something else. Okay. So no case law, no citation. On June 7th, Melnick appeared and informed him that Kenneth Copeland's going to do his Fifth Amendment at the presence of each defendant and their respective attorneys. Judge called Copeland to stand, told him the state was going to be doing a immunity, and Copeland was told that he needed to testify. Mr. Copeland thereafter stated his intention to testify, and Melnick looked towards Steele and Shard and shrugged his shoulders. I think a lot of us have gone to this link. Oh, she couldn't even put it at the time? She couldn't even link the timestamp? Like, come on. Let's see, 112. 112.
And the Fulton DA's office was
I got some kind of sound
that I was representing Mr. Copeland.
What's going on? Okay, here's
apparently
Melnick.
They have had conversations with Mr. Copeland outside of my knowledge and presence. Now, I can't do anything about that because he talked to them without contacting me first. However, he did contact me yesterday.
He's talking
and told me
that
Copeland
doesn't want to do
he was being subpoenaed to testify here today. And I asked him what he wanted to do.
We're just gonna watch for the shrug.
His position had been and has always been that he wishes to exercise his Fifth Amendment privilege against self-incrimination. I have explained to him, and I learned this morning that apparently an immunity order has been entered.
All right. Ms. Hylton, do you wish to respond?
Yes, Your Honor.
All right.
No shrug.
And
where's this alleged shrug? 128. What, did he shrug for like 8 minutes? Where's the shrug? Oh, this is 129.
what you want to do at that point in time, okay?
Now they're like, Copeland, you got to testify.
You have to say no on the record.
Want to. Where's the shrug? Don't even get me started on the irony of this bitch talking about someone in the courtroom making a gesture. Miss shaking her head violently, shoving notes at people. I don't see a shrug. I don't see a shrug. Okay, when asked his age and years, Copeland said, I plead the fifth. Actually, first she said, how old are you? And he said, grown. Which is now my answer anytime anyone asks me how old I am. How old are you? Grown. Period. He never shrugs. Oh, July 77 says she didn't give a time because there's no shrug. That makes sense. She does like, see generally, because it's not fucking in there. She made it up. That's crazy. That's crazy. Y'all, she is such a liar. Dear Nurse Lice says she's Delulu. Erickson says we scroll through a bunch and she did not provide the timestamp. Yeah, this is misinformation. This is crazy. Well, hold on, just don't. It's about to get juicier. The misinformation, at least. Okay, now she goes into the meeting about the contempt. Now, mind you, no case law has been cited. No case law. No statutes. Next page, no case law. No statutes. Next page. Matters addressed during the meeting concerned only the contempt proceedings. That's a lie. And the topics included his rights and representation as it relates, his obligations under these laws, and so on. The entire meeting was taken about, well, we know that. You don't have to bold underline it. We have the record. Brian Steele, defiance of the court's commands and subsequent contempt. She's such a cunt. Sorry. That was like a hardcore word. I shouldn't have said that. Actually, I mean it. I don't take it back. Okay, so she goes on to talk about Steele getting contempt. All right. Argument and citation of authority. To warrant disqualification of a trial judge, the affiant supporting the recusal motion must give fair support to the charge of a bent mind that may prevent or impede impartiality of a judgment. To be disqualifying, the alleged bias must stem from an extrajudicial source and result in an opinion on the merits of some basis other than what the judge learned from his participation in the case. Emphasis added. There is a presumption that the trial judge, acting as a public official, faithfully and lawfully performs the duties devolving upon him. Determining whether an affidavit supporting a motion to recuse is legally sufficient and whether the facts asserted authorize recusal present questions of law. Okay, so now we have two citations. Two citations that don't actually do anything for her. Here, with the exception of defendant's untimely allegation, what is untimely? Regarding a single instance where Steele was shielded by the court for not being prepared. First of all, Steele brought it up right then and there, so there's nothing untimely about it. And secondly, he wasn't unprepared. And thirdly, that was the second time he had done it. Defendant's motions and supplement are based entirely, in bold, all caps, on the defendant's assertion regarding June 10th meeting. No, it's not entirely. Bitch, they have the transcript. Judges shall accord to every person has a legal interest in proceeding or that person's lawyer the right to be heard according to law. No defendant on trial in this case has any legal interest or standing to be involved in the state's motion to compel testimony of Kenneth Copeland. I would argue otherwise, especially since the testimony that they're compelling is against them. I think they have a real interest in it, honestly. I think they have a real interest in it. Hey, at least she cited some case law. We got this bold and I bold and underline, but I use an appropriate font. This bold and underline in Calibri body looks ridiculous. Oh shit, that's it. That's it. That's the whole thing. Okay. That's her whole motion. It's so lame. Here comes, to me, the best part. Remember, in the transcript, remember this, in the transcript, Miss Love, in the very beginning, told the judge that Melnick sent her an email that said, fuck you. Right? She said, oh yeah, and he said, fuck you. And remember, I took a whole pause about what a hero Melnick is, okay? That's not at all what he said. That's not at all what he said. She, and I'm going to start back here, because Boleyn and I were looking at this, and Boleyn pointed out something really interesting, okay? This first email, this is the signature block of Love's first email. And notice there's no proverb. I've attached a version of Bond. Have a good evening, Adrian. Okay? No proverb. Here, somehow attached to the same thing, here, please, Rosser, find the bond by Melnick. I'm attaching a word, blah, blah, blah. Have a wonderful evening, Adrian. Okay, so the next one, here's Sheila Rosser, received. The court is waiting for Melnick. Melnick, right by, here are the proposed bond orders. Thank you. Now, Adrian says the state asks the defendant be required to sign the conditions in front of a notary or a sheriff's official. No signature block on that. Okay? Now, Melnick sends on June 7th to Hylton and Love, afforded, here is a communication which pertains to the YSL case. Her response, all of a sudden, has this African proverb. This is what Boleyn pointed out. She said, if you want to go fast, go alone. If you want to go far, go together. What kind of passive-aggressive bullshit is adding this proverb to your signature block? Nowhere else in the email chain does she have this proverb. Now, all of a sudden, it's there. And let's see what Melnick said. Let's see what Melnick actually said. My concern is for my client. Had I been involved, I would have demanded a much more specific immunity deal. You need him much more than he needs you. You've put him in a terrible position where you know his life is in danger, whether in custody or on the street. He's a marked man from this point forward. Go fuck yourself if you think I'm doing anything besides protecting my client. Go fuck yourself and fuck you are two totally different phrases. They can have totally different meanings. And Melnick said, go fuck yourself if this is what you think. Yeah, because you're putting out these crazy accusations that I'm not caring enough about my client. Like, what? She's so crazy. She's so crazy. All right, guys, I am now... there's no ruling on this yet. So let's go talk about how things move forward. All right, so Miss Love's late ass response. I believe that they will be allowed to have an evidentiary hearing to discuss this. I don't know that this Krause lady is going to recuse herself. Now, she's supposed to recuse herself. She should recuse herself, but I don't know that she will do that, okay? So if Krause does not recuse herself, I gotta look at the calendar. What is today, the 12th? If Krause does not recuse herself, I could see them having an evidentiary hearing sometime around like the 18th or maybe the 25th, okay? The judge will make a ruling right after that hearing. I can't imagine any judge reading or even just knowing there was an ex parte hearing and then reading that transcript and then being like, okay, cool. We're going to carry on the trial. Go back, Glanville, to that jury of yours. I just don't know. I just don't know. I don't have a lot of faith in the Fulton County system. Okay? So, in terms of will it be done properly, what timeline will it be done in, I don't know. I don't know. And you know, it's going to be a bunch of lawyers trying to come together, so everyone's going to have scheduling conflicts. I mean, maybe they won't even hear it until the first week of August. I don't know. I don't know. And then when the judge hears it, there's no way that they can allow, well, maybe they do. Maybe if they allow this trial to continue on after all this shit I just read, I don't know. All right, let me go through your comments. K-Way, if the judge is looking over these motions, don't have Glanville recuse himself. Glanville will just step down himself to save credibility. I don't know, K-Way. I'm really surprised that, excuse me, Glanville has not filed a response. I would think they would file a response. Jiggy says they had informant in jail clothes out of desperation for a conviction and trial. They haven't had any momentum at any point in time. Lock the whole office up. I'm with you, Jiggy. Boss says if things get out of hand, Glanville's going to release the dog on Steele and Little Woody. I don't think the dog, I don't think it's that kind of dog. It's an emotional support dog. It's not going to attack people. I hope. I don't know why Glanville with a service dog is so funny. I know, Kay. I know. That's, yeah. GM, I'm sorry. I don't know what you were asking if it's keeping you out of jail. Shushu says, what a shit show. I'm embarrassed that America courtrooms. I know. It is. It's shameful. And think about this. I spent 25 years of my life attaining an education so that I could sit for the bar and I could become an attorney. And when you see shit like this, it just makes you so sick. It's like I have literally committed my life to America, to the laws of America, to the Constitution of America, and these people are just shitting on it. God, it's awful. Nomenclature, hey, says the craziest part is Woody haven't been crossed yet. I know. Robert says Fawny has already bankrupted the seizure fund. Now she's running out of G's. Ron says no military judge has ever recused himself. That might be the problem, actually. That actually, Ron, is a good point. And maybe part of the reason that Glanville won't recuse himself is because he has that military background. I don't know. Steele put footnote on one of those filings first. I know. Tall Glass, thank you, Tall Glass. You've been doing an amazing job out here in this chat today. I thank you so much. Mike Jones says they need to subpoena Love and Hylton and the judge's phone records. Nomenclature says, I hope Adams crosses Woody. Adams gonna snatch that little friend. I don't think that we're gonna get there. At this point, you know, my mind changes every week, right? But at this point, I'm like, maybe we aren't actually gonna get to seeing any more of Woody. Vintage, thank you for joining us. You're gonna have to rewind to see what you missed. How the judge acting when it comes to Love sounds like an affair. I know, Mike Jones, we've talked about that. We talked about how Miss Love kind of favors the judge's wife. Miss Love is kind of like a less robust version of the judge's wife, so I don't know. Tall Glass says, this is something we'll tell our children. Maybe. Oh, I tell my children all the time. I don't think I'll tell my grandchildren. They're going to be so irritated by me. Oh, Dad, Grandma just went on for hours about that stupid case again. Oh my, Dad, how did you even survive with that woman as your mother? Yeah, so Love was a juvenile judge, and that is part of my theory as to why she thinks she runs this courtroom. I don't know. I'm thinking, here's the thing. Like, Steele wrote those motions with such, like, zealous energy, right? Like, he just, like, so aggressively wrote those motions. And Love, like, her response, I cannot believe it took 48 hours and 42 minutes extra. It just doesn't even make sense. To be in Calibri and then not actually say anything is absolutely wild to me. I felt bad on the judge, I know, Kim, the judge did not talk to Steele appropriately at all. K-Way says, told you this is months ago. This is bigger than beating Thug. The state and those judges don't like Steele. I know, K-Way, you've been saying that all along, and I agree. That definitely has something to do with Steele. It would be nice, Kim, if Caleb Opus came by. Who knows? Let's see. Judge have been biased since the beginning. That meeting put it out fully. You are right, Tanhouse. At least that's how myself and most of my viewers have felt. Tanhouse, welcome. The motions fall into the same umbrella for all defendants. Forgot what's the name. Oh, Cuzzo, that's that Harvey rule. I thought they didn't file their own because the rule, yeah, unpopular. They didn't file their own because of that Harvey rule. But here says, oh yeah, so the kiss the ass. Yeah, it's crazy. I mean, Love just lies right and left. It's so bizarre. Like, most lawyers don't say anything definitively. Like, if you ask us a question, we say it depends. We never really have like a yes or no answer because we're always so involved in the medium shade of gray. I'm really like shocked, and it's really bizarre to see an attorney like I don't know, misappropriating, like just completely saying things incorrectly, and like as if she is an authority and as if it's the truth. And I just, like, I don't know, most of us don't really assert things as facts unless we actually know they're facts, right? Like, it's wild. Woke Ops says, if these parties get in trouble for what they have done here, I'm liquidating my inheritance and leaving this country. Oh, if they do not get in trouble, oh, you better start liquidating. All that's going to happen with Love and Hylton is they probably will have a bar grievance filed, and guess what? The state is going to pay to defend that bar grievance. It's crazy. I'm glad Merchant 8 DA. I mean, look, y'all know about how I feel about government. Like, you don't go to law school and then work for the government because you're the greatest lawyer. Great lawyers work for themselves or like really large firms. Just saying. I wonder how the 911 lady feels about this. I bet Tall Glass, the 911 lady's glad, because she was probably going to have to come back like 8 more times. Maybe the defense should throw some Celebrate and Sell Hawk on Love. Ooh, I don't know what that is, and I don't think they should hurt her. I was tired of that 911 lady. They had to have the 911 lady so they could introduce the 911 calls, okay? Dear Nurse Life says, does a bar require psych evals? If so, how did Love get skipped over? She's the queen of grandiosity. No, they do not require psych evals. And once you pass the bar and once you're admitted to the bar, unless there's a lot of like bar complaints, they don't really pay attention to you. It's kind of like we just go off and run our businesses or do whatever. Yes, nomenclature, welcome. You are a day wonder and I appreciate you. Let's see. Why do lawyers not go by APA? Oh, okay, we talked about that. We have our own book, and it's called the Blue Book, and we go by that. And then we go by the local rules, and every county has its own rules. Like, some local rules require 12-point font, some require 10-point font. Like, one thing I'm not going to do, though, is submit some shit in some 10-point font, because I want people to actually read what I write. Okay? Okay. The double spacing K-way is usually required. We usually double space. But it looks horrible because it's in that Calibri. Mark says this case is over. The state needs to take the L. The state's not going to do that. The state is willing to collude with the judge to get that conviction. So the state is not going to just take their L. Trust. Oh, the ALWD manual. Okay, thank you, Eric. I don't like doing legal writing. I just follow whatever they told me I need to do. We have this brown book. It really only matters that I cite things properly as far as I'm concerned, and then I have other people do all the actual editing for me because I'm not good at editing on my own stuff. When I write stuff, I think it's perfect. I'm like, oh, this is so good. I'm such a good writer. And then the editorial is no way. Okay. I don't know why the state is still fining, because they have to. That's their job, Betty. And they are not allowed to just agree. Yeah. Jiggy says, I don't think the state cares about the RICO anymore, and they're worried that they can potentially face from the feds. Perhaps that's why Miss Love let Miss Hylton take the driver's seat. Possibly, but I think Miss Love let Miss Hylton take the driver's seat because my understanding is there's bad beef or bad blood between Woody and Miss Love. Oh yeah, E. Erickson, you have to order typography for lawyers. You start using typography for lawyers. You follow what that says. You start using these fonts, and all of a sudden you're going to see your opposing counsels submitting motions with your font and your formatting. It happens to me all the time. And I love it. And I think Typography for Lawyers, one of the best books I've ever owned. How can Krause justify, after reading this half answer, she better do the right thing? Krause better recuse herself. Honestly, like, Krause cannot stay on this. I mean, she might, but she's not supposed to. And if she does, let's say Krause stays on and she recuses Glanville. Well, I guarantee the state's going to appeal that. I guarantee. And then if Krause stays on and she doesn't recuse Glanville, of course, Steele is going to appeal that. Hello. So Krause should recuse herself, because then it's not nobody, but less chance of appeal. I was wondering about that part too. What is she talking about there? Wook, I don't know what her whole motion says. The reason it's in that font is because it's meaningless. Terry, welcome. Who turned shit in 52 minutes late? Miss Adrian Love? Not Miss Laura Cadillac. I be turning shit in like 52 days early, okay? I'm not real good at like mathing the days. So if I think it's due on Thursday, I'm turning that hoe in on Wednesday, okay? I do not play against deadlines. Tamika says, did you see Fulton County decided not to build a new facility? They're going to use the $1 billion to refurbish the old jail. I didn't see that. I'm not surprised. I don't think they need a new facility. Just fix what you have. Scrooge says Krause will recuse them because I'm pretty sure she sees how bad the whole country... I think that, but Krause needs to take away. Glanville Hylton trying to scare the federal informant with Fed time only to end up with their own Fed case. You would be the best poetic justice. You're damn right it would be. That would be fantastic. Let's see. She's trying to redesign everything that happened. We never hear her argue longer than this answer in real time. That's true, Tall Glass. Miss Love's pretty brief about her arguments. Love is assuming that if she says it with boldness, no one will check her. Okay. After the answer, 72 pages of fluff. They should take all the grant money. The timestamp is a whole distraction, didn't prove a thing. Yeah, that guy did not shoulder shrug. Miss Love made that up. I hope they get in trouble for their wrong acts, because the fact they did this live makes me sick. What makes me sick is if they did this in this case on TV. Imagine what they've done on cases when there's no cameras in the courtroom. On regular people. On regular people. Oh man, Togla said not even a scintilla of a shrug. I love that, Tallglass. I love it. I love it. Scintilla. Let's see. Love and Glanville have had more head and hand gestures. Miss Love is the queen of head and hand gestures. So I don't understand how you gonna be the queen of gestures out here gesturing all the time and then be mad about someone shrugging. Crazy. Hood Ting says throw the whole case away. LB Rhodes says show us the shrug. Yeah, I love it. Love should be forced to come into the court and show us the shoulder shrug. I agree. I'm hoping that there is an evidentiary hearing regarding this and that we do get to watch it. And if there is in fact an evidentiary hearing, I'm going to imagine that the defense is going to play that video and ask her, where's the shrug? Where's the shrug? You asserted to the court that there's a shrug. None of us see it. Where is it? That's what I would do. That is what I would do. No wonder she got sick writing it. Oh, LB, you're hilarious. I love that. I love it. Oh, shit, I love it. The way this Calvary... Oh, Letitia, listen, the Calibri font is completely unacceptable. I mean, it's acceptable, but it says to me, you know nothing. If I was a professor and I receive a paper in Calibri font, I'm going to think one of two things. Either this is so well written and precise that it's going to be amazing, or it's total shit. But there's nothing in between. There is nothing in between. And Nate says, go to timestamp. That may be what she had an issue with. Well, if that was what her issue with is, why didn't she put that as the range of the timestamp in her motion? It doesn't even make sense. Eva says the Fulton County is embarrassing. Yeah, I agree. Hi, Smut Peddlers. Welcome. Attorney Steele playing chess while the state in Glanville playing checkers. Okay, I agree. That's a really good saying. Jean, we don't know when Krause will make this decision. Like I said, I hope she recuses herself, and I hope it goes to a different county, and then I hope they have a evidentiary hearing regarding it, and I hope we get to watch it. Thank you, Kim. I appreciate the compliment. All right, right, let's see. We don't know when she did it, though. The first email was in March. The second was in June. Oh, GM's saying she could have added that stupid proverb to her email. Doesn't matter. If you have a proverb in your email signature block, I'm judging you. I'm already judging. I am judging you. Wook, I don't know if the judge said she is not going to recuse herself. I don't remember if she said that. But I do think, Jiggy, she should have recused herself already. Terry, no, judges should not be getting directions on their decisions from other judges at all. Wook said she made a ruling that one donation's not enough to recuse. Oh, I gotta find that. Hopefully Boleyn will be able to look for that. Seems like Krause is delaying even more because she should have thrown the cast. I don't know, man. I don't know. What about jury? I think the jury has been... Okay. Ollie. That's a great point. That is a really great point. No, GM, there's not going to be a ruling today. We're going to have an evidentiary hearing first. But, Ollie, the jury at this point, in my mind, this jury has to have Googled what's going on. Maybe not the super, super old people on the jury, but, like, the people our age. Yeah, I'm pretty sure they figured... Like, I'm pretty sure they Googled it. I would have Googled it. I'll be like, why are we off for 3 weeks? What the fuck's going on here? You know? I don't know. I don't know how this jury could not be tainted at this point. I don't know. Ron says Love thinks she can do whatever she wants without question, and I agree with that. Ayana, hey, welcome. Glanville says his girl Love will continue answering for him. No, I don't think it was an accident or coincidence when Hylton called Woody Detective Copeland. A Freudian slip, in fact. Hey, Cammie. Did anyone see the video where Judge and Love appears to be doing hand signals? Yes, Kim, we did, where they do like this. Like the baseball. Hand signals. And don't forget, the cough often sounds quite convenient to break up the defense's role. You know, if they're on a roll, the cough is like breaking that up, it's interrupting, and it rarely interrupts the prosecution. Oh yeah, Cammie, it should have been a burden, when she did the burden shifting, that's a mistrial. And the fact that the judge did not call an automatic mistrial is crazy. AR says, I feel bad for Hylton having to work with Love. That is why we coined her Saint Nikki Hylton, patron saint of courtroom patience. I call her Nikki Hylton because I think she looks like Nikki Hylton. But at this point, and after seeing the ex parte transcript, I have decided that Saint Nikki Hylton, patron saint of courtroom patience, is in fact as culpable as lying Love. Cammie says this case will be in the history books. Maybe. Nene said, my kid's happy. They on hold. They are tired of me. They say I just need to be a lawyer. Hey, anyone who thinks they want to be a lawyer, anyone who's watching, go do it. Like, just go. Follow your dreams. It's never too late. You're never too old. Go do what you're passionate about. Just go. Do it. Tell them Lauren sent you. If Krause doesn't recuse this judge as a fairly new judge, how do you think her career is affected? I don't know. I don't think her career will be affected at all because it seems that the voters of Fulton County don't actually pay attention to what their judges are doing. He says, I don't see any way around in order for this trial to continue. Sad for all the defendants because of unethical conduct. I agree. Glanville allows Love to run his courtroom. Yeah, we've been saying that for months now. It's crazy. Remember how ugly the judge talked to a little attorney? Oh, yes. When the attorney brought it up and he's like, I have a problem with you. YSL Grandpa. How are you going to talk to Grandpa that way? Steele probably pissed off the judge in another case. Yeah, I think Steele has successfully appealed a few of this judge's rulings. Love wrote that response like she already knows it's not going to be refuted. Yes, Uncle Polly, that's exactly how she wrote that response, isn't it? Because it doesn't actually fucking say anything. Crazy. Cammie, Harvey's first name is Bruce. No, row one up. Love is not a judge. She's an ex-judge. She is no longer a judge. She was not reelected. Okay? Thank you, Cammie. I appreciate you. And if anyone's interested, we're putting together the merch. I'm going to show you the back this time properly. Hold on, maybe. Can you see it? Says OG Cadillac. This is the lady dresses. I got a tote bag with it. So hopefully you guys get up in that merch store. We haven't officially launched it yet, but I'm excited. Yeah, nomenclature. Think of the thousands of men and women whose lives have been ruined by this DA, these DAs, and this judge. It's crazy. Yeah, Raymond, I do think the jurors are on social media, and I do think they are probably catching up at this point. At least a few of them, at least the young ones. I'm late, but catching up. Okay, Mrs. Mondo. I'm glad you're laughing. I'm glad you're here. Thank you, E. Erickson. I really appreciate that. Maybe you could be a guest on the show. That would be fun. Ayana, you should definitely do a bar complaint. I don't think we should do a massive one. I think there should be a lot of individual ones. Northside said Judge Suge Knight. Okay, dear woke question. Christians, welcome back. Nikki says she thinks from that response the state is waving the right flag. I don't think so. Cammie said I downloaded the blue book. Ooh. Why? Yuck. I don't even think oh no, I have it over here. Yeah. I do. I have it. I have to have it. I'm a lawyer. Cammie, do you see the way Love's looking at Hylton on those last few days? I mean, Love's always looking awful. I don't know. Jiggy, I don't know. I don't know. My understanding is Woody and Love have beef and bad blood. Dear woke Christian, you say, oh, you can help me with the meetup? That would be excellent. I appreciate it. In the description, there's an email. If you want to email me at that email address, I will gladly coordinate with you. I appreciate it. King J, thank you. Thank you, Secure Your Energy. Gina, I don't know. I think Krause initially said she's not going to recuse herself, but I think she needs to. Claude says the state's case in chief, they need a burden, so they need a little more leeway. Well, they should not make a case unless they can meet that burden. Krause denied the motion for her request. Oh. You guys are so lucky. You guys are so lucky that I have Boleyn. Okay. You guys are so lucky I have Boleyn. She just sent me an update. This update comes from Thugger Daily, which if you're on X, which is formerly Twitter or whatever it's called, Thugger Daily does daily updates, and Krause already signed an order denying, hold on, I'll read this to you. Order denying motion to recuse Judge Krause from hearing recusal motion. This case was randomly assigned to this court to consider motions on recuse Judge Glanville on July 8th. Williams filed a supplemental. The title supplement, the portion seeks to recuse this court from hearing the motion. The court must therefore consider the portion of the supplement seeking the court's recusal before proceeding further. She cites the recusal law. Okay. Assessing whether these three criteria is met does not involve an exercise of discretion by the judge whose recusal is sought, but a question of law determined by the assigned judge. Williams' motion, footnote 2, and lengthy paragraph 52, asserts two bases for recusal of this court. Williams asserts recusal is merited because of a $2,000 donation. He also asserts that it's required because it's inappropriate for any judge presiding in any action where one of the parties holds a judicial office in any other court which sits in the same circuit. Williams' supplement seeking to recuse this court is supported by an affidavit. Therefore, the first two criteria are satisfied, and the only consideration for the court is whether Judge Glanville's campaign donation to this court's re-election campaign warrants recusal. Well, I thought he cited law that said they had to recuse, but okay. Supreme Court has held that a mere fact of campaign contribution to a judge, even from a party to the case, does not warrant recusal where the contribution was not exceptionally large. That's why Steele put this could be considered an exceptionally large contribution. Remember, he did that. One of the judge's colleagues on the court who is recused. Okay, the Code of Judicial Conduct reiterates this point, noting when campaign contributions less than the maximum allowable, an affidavit seeking recusal must allege additional facts demonstrating the need for a recusal. Defendant Williams' additional assertion of the Judicial Qualification Commission in support of his motion is unavailing for two important reasons. First, Glanville is neither a party nor counsel in this criminal prosecution, nor this mandamus action, and Williams cannot make it so by filing recusal motion. 220 will not allow a judge to preside where one of the parties holds a judicial office in the same circuit, does not apply to these circumstances. Secondly, and perhaps most importantly, Williams' motion ignores the clear directive of Uniform Superior Court Rule 25.4. That rule directs that in a multi-judge circuit, like the Atlanta Judicial Circuit, a recusal motion shall be assigned for hearing to another judge, and the selection shall be made by use of the circuit's existing random impartial case assignment method. Okay, so I guess the law says that when you have a circuit with a bunch of a bunch of judges, then the recusal can be heard by one of those judges within that circuit. And $2,000 is not enough. All right, fair enough. So, Krause is definitely keeping herself in, okay? Krause is keeping herself in. And I'm assuming, will have some sort of evidentiary hearing by hopefully the end of next week. Because Krause did make it, she made it very clear that this is a top priority because there is a jury sat already. Okay, I hope the hearing is the day you're there. Oh shit, it'd be so cool. I really hope there's trial when we're there. We're gonna be there August 13th. All right, so guys, that's it. I feel like I've been talking so I have. It's been like 3 hours of my own voice. Okay. Thank you everyone who has joined us today. Thank you everyone who has hit like, everyone who subscribed, everyone who did a super chat today, everyone who did a super chat in the past, everyone who has sent money via Cashapp, everyone who has followed any of our links. We appreciate you so very much. I will be back next Friday, 10 a.m. Central. Maybe we'll be talking about this case. Maybe I'll be talking about another case. I don't know. Who knows? Who knows what's going to go on? I appreciate y'all. Thank you so much for being here, and I can't wait to see you again next time.